gold leather holster. I can't really remember the type of handle, but it wasn't what you call a blue finish, which is that dark black color. It was more of like, nickel chrome type look.
Do you remember the handle or anything about it?
No, I don't remember the handle. Like I said, I don't remember the color of the handle.
For the jury, if you were standing outside those, what I call, again, the American doors, if you're outside looking into where the couches and the ottoman and everything is, where you're dead, or you would hang out and eat dinner.
Okay.
If you walk into the doors, tell the jury where this drawer or this dresser or whatever it is where you found this.
So if I would have had my back to the door, the couch would have been right in front of me, and that piece of furniture would have been right here to my right.
When you found the gun, what did you do with it?
I didn't do anything with it
Did you
because
touch it, pick it up, move it, or just look at it?
I kind of maybe grabbed it enough to kind of like look at it, but I did not pull it out of the drawer because I had the AT&T guy in the basement with me. I didn't want to freak him out. But no, I never really fully picked it up and looked at it. So yeah, that would have been the piece of furniture, the lamp there.
Talking about right here, this is Thrasher 226.
Yes, that was the piece of furniture that I saw it in on the top drawer.
So this is the sliding doors coming in on the right.
Yes, sir.
Why did you start thinking about this gun? What made you think about gun, and who did you start telling about this gun?
When?
On the 5th.
On the 5th? So, after, talking with her and, the comments that she's made previously, everything was just, I was getting red flags and all. And when I went down to check on the CPAP machine and the shotgun, after I checked the shotgun, I remember seeing that revolver. So I just wanted to go over and look to see if it was still in that drawer.
So on the 5th, did you go to see if that gun was there?
Yes.
And what happened?
So I went and opened that drawer and that gun was not there. And closed the drawer back, didn't look anywhere else, and I went back upstairs. And then on my way back upstairs, I noticed a drop of blood on the floor. It was smaller than a dime, and it was, kind of almost right there before you get to the stairway.
Right by the stairs at the corner there?
So I didn't want to bring anything up at that time because this, like I said, this is prior to finding my dad. And, I didn't want to be like, hey, there was I went to go see if there was a gun down there and it's not there anymore. But, back when I found it, Melody was gone. My dad was at work and I just forgot all about it. But for some reason that day when I went to go check to see if the shotgun was there, it reminded me that that gun was in that drawer. And just something told me to go just check to see if it was still there.
Did you, afterwards on the 5th, when law enforcement came, did you talk to them?
Yes.
Did you
might have been today, yeah. Thank you, sir. rise. Superior Court is now in session. Honorable Judge Martin is presiding.
Good morning, please be seated. On the record, the state of New Jersey versus Paul Canero, it's indictment 19020283. Counsel for the record.
Good morning, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Good morning, Judge Chris Decker, Assistant Monmouth County Prosecutor for the state.
Morning.
Morning, Your Honor. Still an attorney on behalf of Mr. Canero, who's present in the jury box.
Good morning, Judge Andy Murray, also for Mr. Carroll.
Morning. All right. So prior to today's date, I've had the opportunity to receive the pre-sentence report. There were some slight modifications due to the change in the date for the sentencing from May the 12th to May 19th. There's also some other minor modifications that were made. I've also received from the defense, I did not receive a sentencing memo. However, what I did receive was character letters that I have read in their entirety, and they will be incorporated in the pre-sentence report for purposes of the sentencing, because that was what was requested. I also received from the state a sentencing memo that I have read and contemplated. I've also received a few letters from Jennifer Canero's family that I have reviewed, and I also received this morning some information from a friend of Keith, Darren Altman, and also an impact letter from Corey Canero. So I have reviewed all of those documents. I'm going to ask and remind everyone, as I've said from day one, that I do not need for anyone to reiterate what they've already said. I promise you with all of my heart that I've read everything more than once to be prepared here for today. But with that being said, I will now ask the state to move the sentence.
Thank you, Judge. This defendant appears before the court for sentencing. At this time, Your Honor, I would note that some of the victim's family and friends are here, and when it's appropriate, Your Honor, if we could, before the state speaks, if I could have Jennifer's sister and mom speak. Also, I would note that Darren Altman is here, a friend of the family who would also like to speak.
Okay, would you want them to speak first and then for you to speak?
If that's okay with the court, Judge.
Okay, so for the individuals that are going to come up to speak, we have a podium right here to my right. I'm just going to ask for you to stand at that podium. I find it may be more comfortable for you to be able to have that so you can hold on to something. All I'm going to ask is that anything that you want to say, direct it towards me, not towards the defendant, towards me. You can say what you want to say, but I want you to direct it towards me. Does everybody understand that? Okay, great. Everyone's shaking their head yes. Ms. Wallace, you can indicate who is going to speak first.
Thank you, Judge. If we could have Darren Altman.
Okay. Mr. Altman, come up. Sir, I'm going to ask you to state your full name for the record and spell your last name, please.
My name is Darren Altman, and my last name is A-L-T-M-A-N.
Okay, go ahead, sir.
For 24 years, almost 24 years, I worked for Keith Canero at Square One. He was more than just an employer. He was a person who believed in me when I needed it the most and gave me the opportunity to build the career that I have today. Meeting Keith was one of those crossroads in my life that changed everything. Over those many years, he became a true friend and a constant source of support to me and my family. His loss has left a void that is impossible to fill. I remember countless evenings with Keith and Jennifer, joined my wife and I for dinners. Those nights were filled with laughter, wonderful conversation, and in many cases, good food. Years later, when I was faced a challenging time, being confined to a wheelchair after an accident, Keith and Jennifer were there to reassure me that they would be there for me and my family. They made it clear, whatever I needed, they would be there for us, and they always were. And it's hard to imagine how my life would have turned out had our paths not crossed. The impact of their kindness and support is something I will carry with me forever. It has left a mark on my life that I will always cherish. Your Honor, the loss of Keith, Jennifer, and their children is an immeasurable tragedy. For this reason, I respectfully ask the court to consider the maximum sentence for Paul Canaro. It would not only bring a measure of justice to the Canaro family that was taken from us, but it would also be justice for the fortunate ones who need them. Thank you.
Thank you, sir. Appreciate it.
Judge, would it be possible to have Jennifer's mom and sister come up together?
Absolutely.
You guys can just stand right at the podium together.
The only thing that I ask is I'm going to ask both of you to state your full name for the record, but then whomever is going to speak first, if you can just say your name so that we know for the record who's speaking, okay?
I'm Bonnie Caritas.
Okay.
Vic Caritas.
K-A-R-I-D-I-S.
Thank you.
My mom.
Okay, go ahead.
Good morning. Your Honor, members of the court, and all of you who have worked diligently to bring justice and closure to my family. I thank you for all you have done. I believe you will do what is right and remove this killer, this monster, from society for good. I am sorry for all of us who have had to sit through those weeks and hear those horrible, gruesome details. This is what life has been for me, my husband Velasquez, and daughter Bonnie, ever since Paul Canaro slaughtered my beautiful family, murdering his own brother, my daughter, my grandchildren, Jesse and Sophia. He stole the source of joy and happiness in our lives and replaced it with bottomless sadness, sorrow, and grief. Sadly, my husband Velasquez is not here today. He died without knowing that justice was done for our family. During the trial, the defense attorney once said to a witness, "You don't know what you don't know." I would like to tell you what you do not know. Jennifer, my daughter, was a beautiful person. She was warm, vibrant, caring, wife, daughter, sister, friend, and most of all, a wonderful mother. She was not just loving, but accepting of everyone for who they were, which made her even more special. She loved each person in her life and brought out the best in all of us. Keith was a loving and devoted father, husband, son, and brother. He had a brilliant mind, and his success was only because of his incredibly hard work and doggedness. He was the son I never had, a true, loving son. A man who would be there to help anyone in need. Jennifer and Keith had the same birthday and sadly now share the same day of passing. They loved each other. They each took the other's families into their lives and made it all bigger and better. Keith built that house to have a family in a beautiful place and to be a place for the families to gather. My grandson, Jesse. I wish I could have seen him grow up. He had a mind like his father's, so smart, deeply interested in history, the kindest heart, cared about everyone. Sophia, my beautiful granddaughter, so young, she loved to dance, sing, play with makeup. She put on makeup better than I did. She was joyful, spirited, and kind like her mother. Jessie would be graduating now and going to college in the fall. Sophia, high school. Lives stolen. There's not an hour in the day I do not think of them. And to think of them is to think about this terrible thing. How their last moments were terrifying, painful, and horrific. How each of them looked at their Uncle Paul as he killed them. Killing them in front of each other like an animal. Most days it is hard to get out of bed because of these thoughts. Every birthday, anniversary, family, holiday is now filled with pain. Paul Canero's horrific and despicable actions have caused agony and grief beyond what anyone should endure. In an act of pure evil, he took the life of 4 innocent people, his own flesh and blood, out of greed and selfishness. He disgusts us. He represents the very worst of humanity. My family and I live with traumatic grief, depression, and anxiety, worsened only by him dragging us through these 7 years. He never once exhibited any remorse at all. Despite overwhelming evidence, he would not confess. He could have stopped this from dragging on, but no, he sits here today with his evil soul, still not admitting what he has done. He ripped the love and hope from our lives when he murdered Jennifer, Keith, Jessie, and Sophia. I hope it is impossible for him to ever, ever, ever be free. Our family he gruesomely murdered should be here in this world today, making beautiful memories. A son I could call for advice, a daughter who was a part of me, my grandchildren who I could hug forever and ever. 1,000 years would not be enough. Thank you, everyone.
Thank you very much.
Your Honor, my name is Bonnie Caritas, K-A-R-I-D-I-S.
Thank you.
And I am the sister of Jennifer Caritas Canero, the sister-in-law of Keith Canero, and the proud aunt of Jessie and Sophia Canero. Jessie was 11 years old, and Sophia just 8 at the time of their brutal murders and moments in life. An entire branch of our family was erased 7.5 years ago, 2 days before Thanksgiving. We are grateful to this court, to the prosecutors, law enforcement, the victims unit, witnesses, and the jury who worked tirelessly to bring this case to sentencing. But my father, Vlasis Caritas, he did not live to see this day. He passed away without knowing that there would be accountability for the loss of his family. I am here today so the court understands the staggering depth of not only what was taken from us, but who was taken. Jennifer was my younger sister, my best friend, my only sibling. I miss spending time with her, talking to her. She talked a lot. She really liked to talk. Laughing with her, our private jokes. Jennifer made people feel safe. She made people feel loved. She never let anyone feel alone. She was the heart of our family and a devoted mother who built her entire life around her children and anchored our family with love. I miss her every single day. Keith. Keith was the brother I never had. I could count on him for anything. I miss his advice and talking to him for hours on end. I greatly admired him. He was intelligent, driven, witty, generous, and deeply principled. He built a life of success and integrity, but more importantly, he lifted everyone around him. He adored his children, and he was raising them to be strong, kind, human beings. He was loyal to his family, committed to providing for them, and endlessly supportive of the ones he loved. Keith included and supported his older brother Paul, but Paul became consumed by jealousy, jealous of Keith's life, his success, and the man that he was. Paul's small mind, warped by jealousy and greed, turned into deliberate, calculating, murderous deeds. But Paul did not just take Keith and his family's lives. He tried to steal the legacy of a man whose character, compassion, and integrity he could never, ever come close to being. In his violent acts, he attempted to erase everything Keith built. As a father, as a husband, as a friend, and as a human being. But Paul will never succeed at that, never. Keith's legacy lives in every life he touched, and no act of cruelty can diminish the man he truly was. Jesse was a bright, curious, and thoughtful 11-year-old boy. He had a sharp mind, like his father, and a gentle heart. He took his role as Sophia's older brother, seriously, protecting her, guiding her, and standing by her side. Jesse was remarkably tech-savvy for an 11-year-old boy. I missed the way he would confidently explain which phone was better or why one iPad made more sense than the other. He loved sharing what he knew, and I relied on his little lessons more than he ever knew. Losing his voice, his curiosity, and his guidance is a loss I feel every single day. Jesse had a whole future ahead of him. Dreams he was beginning to form, talents he was just discovering. It is devastating to know that a child so full of potential and goodness will never get the chance to grow into the man he was meant to be. Sophia was pure light. She was joyful, playful, and full of life, in a way that could brighten any room. She loved to sing, dance, bake, and play. Her laughter was constant, her spirit contagious. She brought happiness wherever she went. I miss playing golf with her, hearing her sing, watching her dance without a care in the world. She was at the beginning of everything, every dream, every milestone still ahead of her. I can only imagine the incredible young woman she would have become. I would give anything to just have one more moment playing hide and seek with Jesse and Sophia, to hear their laughter again, to see their smiles, to know they were safe. We are not just grieving who they were, we are grieving who they would have become. The sheer malice and betrayal behind this is unbearable. They were executed and tortured by someone who was family, Uncle Paul, someone driven purely by greed and money. A home is supposed to be a sanctuary. They welcomed him into their space, and he took their lives for material wealth. The calculation and selfishness required to look his own niece and nephew in the eyes and murder them, an entire family, is a level of evil that is not comprehensible. 8-year-old Sophia fought against a grown man after watching her family destroyed. This was not only murder, it was sustained cruelty. Since that day, our lives have been shattered. Every milestone they should have had is now a painful reminder of their absence. The Satan in this room stole decades of laughter, holidays, graduations, and weddings from all of us for temporary material wealth. There is a permanent agonizing void that is filled with pain, sorrow, and grief. While my family's voices were silenced, Their lives and the value of their lives should never be diminished. There is no sentence that can bring my family back. And there really is no justice in my mind for these crimes. But for a crime rooted in greed and complete disregard for human life, there must be accountability, maximum accountability. Your Honor, I respectfully request that you impose maximum sentences allowed by law. The defendant must be removed from society. Thank you for listening to my family's voice.
Thank you both. Ms. Wallace.
Thank you, Your Honor. Your Honor, in the state sentencing memo, we laid out our analysis of the factors such as merger, the aggravating and mitigating factors, as well as the Yarborough guidelines. So I won't rehash every single argument that was made in our submissions. However, there are a few things I would like to highlight if the court would indulge me.
Okay.
In terms of aggravating factors 3 and 9, the defendant's conduct at 15 Willowbrook Road was nothing short of a massacre. Keith, Jennifer, Jesse, and Sophia should still be here today. What he did to that family, to those children, was unspeakable. It defies any type of humanity. This was not an accident. This was not a fit of passion type of a situation. His conduct was premeditated, it was calculated, and it was planned every step of the way. And the thing about it is that there were so many instances over that 9-hour period where the defendant could have made a different choice. Even after he murdered his brother, he could have just gotten in his car and left, just leave. But he chose murder over and over again. The state had the opportunity to read the character letters that were submitted on behalf of the defendant. And what's interesting about those letters, in addition to all of them sounding oddly similar, is that in each of those letters, the individuals indicate that they believe the defendant to be a responsible person. Responsible. One look at the evidence, the actual evidence, that the jury sat and listened to would indicate that the word responsible and Paul Canaro don't belong on the same planet, let alone in the same sentence. This is a person who was living beyond his means, stealing from the victims, and then doctoring bank records to cover up his crimes. And when the gig was finally up, when Keith caught him for the second time, instead of manning up, instead of just facing the consequences of what he did, instead of being responsible, he thought it better to wipe a family of 4 off the face of the earth like it was nothing. That is not responsible. That is the epitome of selfishness, and that is a coward. Sneaking up on your family and ambushing them in the sanctity of their own home, where they should have been the safest. And I would note, Judge, that these were not strangers, though that would be bad enough. These were the defendant's own family members. I submit that if he is willing to do such unspeakable acts to his own family, there is no limit to his capacity for evil acts. In terms of aggravating factor 1, Your Honor, the state would emphasize both the terror and the pain that the defendant inflicted on the victims. As the court will recall, Keith was shot no less than 5 times, with one of those shots being a contact wound to the head. The defendant then invaded their home, and inside that home was Jennifer, a 45-year-old mom. Her husband had just been murdered outside. She was alone in the house, unarmed, the power was out, the generator was off, and there was an intruder inside her house. I would submit that is terrifying in and of itself. Now add to that the fact that Jennifer had her 2 babies in the house with her. Jennifer was hunted down, as were her children. As the court is aware, Sophia was stabbed multiple times, and she had defensive wounds, or wounds that were consistent with defensive wounds all over her body. That little 8-year-old, 45-pound girl fought for her life against a 200-pound grown man wielding a knife. I submit that the terror that he inflicted on the victims cannot be understated. As far as the physical pain, I'm not going to belabor all of the injuries. I think we've heard enough of them. The jury's heard them at trial. The court has heard them. The children were stabbed and then left
to inhale smoke. That is a shameful thing to do to any human being, let alone your own family members, let alone 2 children. Your Honor, the state has submitted to the court a letter that was written by Corey Canaro. I'm not going to read that letter, Judge, but I do want to just, in light of that, I think that the state would be remiss to forget the impact that the defendant's actions had on Corey and his family. Corey was also Keith's brother and his best friend. Corey lost his brother that day, his sister-in-law, his niece, and his nephew. And then to add insult to injury, the defendant accused Corey of being responsible for these atrocities. Obviously, the jurors recognized that for what it was. Corey misses his brother, his niece, his nephew, and his sister-in-law, as do his children and their cousins. Judge, based on what the jury convicted the defendant of, as Your Honor is clearly aware, the defendant is facing 4 mandatory sentences of life with no possibility for parole. That is obviously the highest sentence that can be received in the state of New Jersey. The state is respectfully requesting that the court run those sentences consecutively, pursuant to Yarborough. Keith, Jennifer, Jesse, and Sophia were a family, but they were also 4 unique individuals, and they deserved to live full lives. Keith and Jennifer should have been able to grow old together and watch their children grow. Jesse and Sophia should have had the opportunity to finish out their childhood years, their adolescent years. As the family indicated, all of the milestones stolen from them. Their middle school years that were ahead, 8th grade graduation, high school, proms, driver's licenses, first dates, etc. Those were some of the big ones, but there were smaller ones too, like the family's weekly movie nights that the 4 of them enjoyed together, family vacations, play dates that the children had with their friends and their cousins, Sophia's Ninja Warrior classes, and Jesse's lunch dates with his dad. Jesse was 11 years old when he was murdered, and Sophia was 8. Jesse would have been 18 years old today, and Sophia would have been 15. Their friends and their family miss them and are deeply wounded by their loss. They were a good family, and they should still be here today. But they are not defined by their last moments, Judge. And with that, I'd like to leave off with just a quick story of something I learned about Sophia. In speaking with the family, I learned that Sophia at her school had something called a buddy bench, and that was basically where children who felt lonely or needed a friend would sit on the bench, indicating for other children to come over to them. And what I learned was that Sophia was always the child that would go over to the other children and make them feel comfortable and welcome and be their friend. That is who she was, and that is her legacy. They were a good family, and they should still be here today. It has been 7.5 years, Your Honor, 7.5 long years that the family has waited, that their friends have waited for justice. And today is the defendant's day of reckoning, and the state would respectfully ask the court to sentence him accordingly. Thank you.
Thank you.
Judge, I'm just going to start off by acknowledging the tragedy here. It's not lost on the defense that 4 lives were tragically lost, and that, as I think the first gentleman indicated, the amount of loss and devastation is truly immeasurable. To the friends, to the family members, the community members of the victims. And so there's nothing that I can say to mitigate that tragedy. But again, it's not lost on us. And with that said, Judge, my role here obviously is to speak on behalf of Mr. Canaro. So with that, I would note, as the court indicated, there were letters submitted by the friends and family members of Mr. Canaro. The purpose of those letters was just to demonstrate that Mr. Canaro is supported in his support. However, as everyone knows, the jury made findings in this case, and based on those findings, the sentence in this case is mandatory. It's life without parole. And Mr. Canaro is well aware of that. He's prepared to receive his sentence today. And
I understand the state is arguing for consecutive life sentences versus concurrent life sentences, and the defense would only offer that it's essentially two different ways of saying that Mr. Canaro is going to be spending the rest of his life in prison without the possibility of parole. So with that, Judge, the only other thing I'll add is I did advise Mr. Canaro that the court will extend to him an opportunity to speak, and in response to that, Judge, Mr. Canaro he maintains his innocence, and he has nothing further to add at this time. Thank you.
Mr. Canaro, stand. I heard what your attorney said. In light of what you've just heard, is there anything that you want me to say before I impose sentence?
No, Your Honor.
Sure?
Awesome.
Okay. The defendant was found guilty by a Monmouth County jury on February 13th, 2026 of 4 counts of first-degree murder, 2 counts of first-degree felony murder, 2 counts of second-degree aggravated arson, 1 count of second-degree possession of a handgun for an unlawful purpose, 1 count of third-degree possession of a knife for unlawful purpose, 1 count of fourth-degree unlawful possession of a knife, 1 count of second-degree theft, 1 count of second-degree misapplication of entrusted property, and 2 counts of third-degree hindering one's own apprehension after a 6-week trial. As a part of the verdict, the jury unanimously found defendant committed these 4 murders by his own hand, and also found 4 aggravating factors to mandate a sentence of life without parole for Keith and Jennifer's murders, and 3 aggravating factors for a sentence of life without parole for Jesse and Sophia's murders. To be clear, only 1 aggravating factor is necessary to sentence you to life without parole. For each of the 4 murders, the legal question left for this court will be whether these sentences should run concurrent or consecutive to each other. The court must also consider the sentence for the remaining counts that defendant was found guilty. I've reviewed the pre-sentence report. I've incorporated the letter supplied by the on defendant's behalf. I've also incorporated the victim's family's written and oral statements made here in court today. I find the pre-sentence report adequate for sentencing purposes. Defendant is 59 years old, married, father of 2 adult daughters, both of whom testified at this trial. Defendant's wife did not testify. Defendant denies any substance abuse evaluation issues, indicating he drank 1 to 2 drinks per week prior to his arrest in 2018. He claims to have PTSD at the age of 33 while working as a consultant. He traveled for work and claims he observed many violent crimes. As for medical history, he reports 20-plus surgeries from 2012 to 2018 after being involved in a car accident. While he reports being permanently disabled since 2013, defendant reports to being in good physical health to his pre-sentence report investigator, and he also does not manifest any observable disabilities. Defendant was a partial owner of 2 businesses, Square One, where he had 10% ownership, and EcoStar, where he had 50% ownership. Despite those ownership interests and salary, because he was deemed permanently disabled, he was also receiving $2,300 a month in Social Security and $7,200 a month in Social Security disability, totaling $9,500 a month at the time of his arrest. He was also the homeowner with his wife of a home in Ocean Township that we heard about, which was later sold. While incarcerated for these murders, EcoStar was sold in 2020 and Square One was dissolved. Defendant reports he is one of 3 children, Keith, who the jury convicted defendant of murdering, and Corey, who defendant claims is an alcoholic with mental health issues, abusive, and a pathological liar. It should be noted, and it was mentioned again here today, a big part of defendant's defense included an allegation that law enforcement should have looked into Corey a little bit further for these murders. The jury outright rejected that argument, finding defendant guilty of all 15 counts in less than 5 hours. Defendant has no prior record. Defendant was charged with insurance fraud pursuant to a separate indictment, but the state will dismiss that charge today after the sentence is imposed here, and because defendant has no ability to pay if defendant was convicted and restitution was ordered. I have also reviewed the pre-sentence report for the victim's statements that were provided by Bonnie Caridius, who spoke about the ruthless, premeditated murder of Jennifer, Keith, Jesse, and Sophia due to greed, anger, and jealousy by the defendant. To you, I agree with you, and I'm very sorry for your loss. I will incorporate the following facts into the aggravating versus mitigating sentencing analysis. In this case, there was an avalanche of evidence pointing to defendant being a callous, heartless, brutal killer of his brother, his sister-in-law, and 2 innocent kids. It's not a tragedy. It's a flat-out killing of innocent people. Tragedy is a much different word. He clearly planned these killings in the hours prior to driving the 20 minutes to Keith and Jennifer's Colts Neck house. Defendant's actions were calculated, from turning off his own surveillance cameras, to choosing ammunition that would cause massive destruction, to loading the gun cartridges with bullet after bullet after bullet, while in his basement of his house, only to leave his house in darkness with an evil, merciless eye to assassinate and annihilate an entire family from this earth. Defendant's plan took shape during that 20-minute drive to include shutting off the power in the victim's home once he arrived. That action describes a premeditated, targeted act of violence designed to disable home security systems and power to create vulnerability and to ensure that the defendant had the advantage against his brother and his family. Once the defendant disabled the power, he deliberately and tactically waited outside for his brother to execute the attack. Defendant then shot his brother multiple times, including an execution-style shot to the head, a coup de grace shot, as Keith's immobile body laid face down on the ground. It is clear to this court the defendant acted with a depraved heart, showing no regard for human life, let alone his brother's life. After extinguishing his brother's life, defendant set his sights on his dead brother's innocent and unaware family. While defendant is the only one that could tell us the timeline of the massacre inside this home, it would appear defendant set his sights on Jennifer, Keith's wife. Unknowing what had happened outside, Jennifer left the bed that her and her husband were just in, due to hearing these gunshots that ended her husband's life, and went towards the front door to see what happened. It seems that while there was no power to Jennifer's house, there must have been some sort of lighting. Or, referring to Exhibit S-170 from the trial, the FLIR 1 Pro thermal camera in defendant's possession, depicting the heat sensor that would show heat coming off the bodies of Jennifer, Jesse, and Sophia, and that would just make you a tactical killer. I say this because when defendant entered Jennifer's home, he shot her in the head with precision. That did not occur without any form of light or other sensory device. The gunshot wound to Jennifer's head tracked front to back. Jesse, age 11, Sophia, age 8, nearby, must have heard the gunshot that wounded their mother, or the multiple gunshots that killed their father, or both, because both of them left their bedrooms, and that's when the defendant potentially shot at Jesse, according to the evidence. Defendant then grabbed a knife and stabbed both Jesse and Sophia multiple times. Kids, innocent kids, they hadn't even had a chance to start their lives yet. We heard just about in this courtroom about all the life they had left to live. You stole it. There is no way to know for sure when, but Jennifer was also stabbed multiple times in the chest, back, and abdomen, either before or after the defendant stabbed her kids to death. Defendant stabbed Jesse 7 times in the upper body and torso. Defendant's injuries was left breathing but severely disabled. Defendant stabbed Sophia repeatedly over her body well over 40 times, including defensive wounds. One stab wound went right through her face and another through her chest cavity. Sophia was also disabled and left for dead. Neither child, without parents to protect them, due to your unconscionable actions, could get any help, not even for each other. Again, defendant is the only living person who can recount exactly how these events unfolded. But the evidence reveals a chilling and calculated sequence. After carrying out these horrific acts, defendant went into the basement and deliberately set a slow-burning fire carefully designed to give himself enough time to return home and manufacture an alibi. This was not panic. This was not confusion. It was cold, deliberate malice. Defendant engineered that fire to destroy every trace of what he had done, to erase the evidence, to erase the victims, and to reduce even their remains to ashes. As thick smoke consumed the home over the next several hours, Sophia and Jesse suffered further agony through smoke inhalation, injuries that ultimately contributed to Sophia's death. Even in their final moments, the suffering continued because of your calculated actions. There's no softer or gentler way to describe what happened here. Defendant committed familicide. This was an annihilation of an entire family, a mass murder carried out by the very person who should have protected them most. And why? Because defendant carefully constructed lies, because defendant's carefully constructed lies were collapsing around him. The manipulation that defendant used to control those closest to him was no longer working. Exposure was inevitable. The mask was slipping. The truth was about to emerge. Defendant was driven by greed, jealousy, selfishness, and a ruthless desire to preserve himself at all costs. Defendant's selfishness did not end with the slaughter of Keith and his family. It continued as he drove home and deliberately set fire to his own home, recklessly placing his own family in danger of death. Even then, his purpose never changed. He wanted to destroy the bloody clothing, the physical evidence, and every item that could expose him as to the depraved killer he truly was. The irony is staggering. Defendant was willing to burn down his own home, the very place where his children should have felt safe, simply to protect his secrets and conceal his monstrous actions. He desperately wanted to preserve the false image he had created for himself. The caring husband, the good father, the victim of some terrible attack. But the evidence tears that lie apart, piece by piece. Defendant was never a victim. You were the cause of all of it. And the destruction did not stop there. The evidence shows he attempted to set one of his own vehicles on fire in another calculated effort to destroy incriminating evidence hidden inside. Every step he took was driven by deceit. Every action revealed another layer of manipulation, another desperate attempt to escape responsibility for the horror he created. The lies were relentless. The deception was constant. One of the many heartbreaking parts of this case was watching the devastation inflicted upon the defendant's own family in the aftermath. His actions left them displaced, homeless, and shattered, while his children tried to comfort the very man responsible for destroying their lives. There are few betrayals more profound than that. A father is placed on this earth to protect children, to protect his own children, to protect his niece and nephew, to shield them from harm, to sacrifice for them when necessary. You did the opposite. He sacrificed everything that belonged to them their home, their security, their peace, and their future, all in a desperate attempt to save yourself from the consequences of your own evil conduct. And while it is almost impossible to comprehend what his children must now endure, my heart goes out to them also, because they must live with the terrible realization of who their father truly was and is. On that day, defendant was not a father. He was not a protector. He was and continues to be a manipulative, cold-blooded killer who destroyed every life around him in a ruthless effort to preserve his own. With that backdrop, the court will consider the aggravating and mitigating sentencing factors. As I pointed out, the defense requests that the court take into consideration the 9 letters from defendant's family and close friends, as well as any appropriate mitigating factors, and I will do so. The state submits that there is no applicable mitigating factors and argues that aggravating factors 2C44-1A1, 1A2, 1A3, and 1A9 should apply. In determining a sentence, the court must consider the nature of the offense and the relevant aggravating and mitigating factors. State v. Zuber, 227 NJ 422, 450, 2017. The court is required to consider all the aggravating and mitigating factors to find those supported by the evidence. That's State v. Dalziel, 182 NJ 494, 505, 2005. The court's personal views in rectifying social ills cannot be a factor in determining punishment. State v. Eichert, 369 NJ Super, 610, 621, Appellate Division, 2004. Sentencing decisions follow a qualitative rather than a quantitative analysis. State v. LV, 410 NJ Super, 90, 108, Appellate Division, 2009. Cert if denied, 201, New Jersey, 156, 2010. The factors are not simply balanced and afforded equivalent value. The court must focus upon the offense when formulating a sentence. State v. Roth, 95, New Jersey, 334, 368, 1984. State v. Hodge, 95, New Jersey, 369, 377 through 379, 1984. And State v. McFarland, 224, New Jersey, 458, 466, 2016. And lastly, State v. Fuentes, 217, New Jersey, 57, 72, and 73, 2014. Thus, the statute requires a thoughtful weighing of the aggravating and mitigating factors, not merely counting one against the other. State v. Denman, 347 NJ Super, 457, 467, 68, Appellate Division, cert if denied, 174, New Jersey, 41, 2002. An explicit statement on the record of the aggravating and mitigating factors found and how they were balanced is required. That's State v. Natale, 184, New Jersey, 458, 489, 2005. The court has far-ranging discretion as to the source and types of evidence used in determining the punishment imposed. State v. Davis, 96, New Jersey, 611, 619, 620, 1984. NJSA 2C44-1A sets forth 15 aggravating factors a court shall consider when imposing a sentence. Where the legislature has already taken certain aspects of the nature and circumstances of the offense into account in grading, the court may not consider those same aspects against the aggravating factors. State v. Pineda, 119, New Jersey, 621, 1990. Thus, a victim's death generally may not be viewed as an aggravating factor in a homicide. State v. Carey, 168, New Jersey, 413, 425, 2001. However, the nature of the death can be considered in sentencing for homicide. State v. Soto, 340, NJ Super, 47, Appellate Division, cert if denied, 170, New Jersey, 209, 2001. The court finds aggravating factor number 1, the nature and circumstances of the offense and the role of the actor therein, including whether or not it was committed in an especially heinous, cruel, and depraved manner. This factor has been held to include the cruel manner of the attack, State v. Roth, 95 New Jersey at 367, the brutal and senseless nature of the stabbing, State v. Bowens at 639, and the painful, dreadful killing of a child by fire, State v. Lewis, 223, NJ Super, 145, 153, Appellate Division, cert if denied, 111, New Jersey, 584, 1988. In this case, this factor is applicable and is entitled to significant weight. Under this factor, the sentencing court reviews the severity of the defendant's crime, the single most important factor in the sentencing process, assessing the degree to which the defendant's conduct threatened the safety of the direct victims and the public. State v. Lawless, 214, NJ 594, 609, 610, 2013. In doing so, the court focuses on the gravity of the defendant's conduct, considering both the impact upon the immediate victims and the overall circumstances surrounding the criminal event. It is 609. When assessing whether a defendant's conduct was especially heinous, cruel, or depraved, a sentencing court must avoid double-counting facts that establish the elements of the irrelevant offense. State v. Fuentes, 217, New Jersey at 74 and 75. To demonstrate this factor, a sentencing court may consider whether the aggravating facts show that a defendant's behavior extended to the extreme reaches of the prohibited behavior. It at 75. In State v. Rivers, the Appellate Division found a factual basis for an especially heinous, cruel, and depraved manner of an offense where the defendant intentionally shot unarmed victims and pointed his gun at others. 252 NJ Super, 142, 152 to 154, Appellate Division 1991. The facts in this case establish conduct that falls squarely within the most extreme reaches of brutality contemplated under aggravating factor number 1. Defendant did not merely kill his victims. He subjected them to prolonged, savage, and excessive violence that went far beyond what was necessary to cause death. The sheer number and nature of the injuries inflicted upon each victim demonstrate calculated cruelty, domination, and a complete disregard of human suffering. Defendant intentionally shot Keith Canero multiple times. The attack culminated in an execution-style gunshot wound to Keith's head. That final shot was not necessary to accomplish the killing. It reflected deliberate and methodical violence inflicted upon a defenseless victim laying on the ground with his face in dirt. The multiple gunshot wounds culminating in the fatal shot to the head demonstrated an unmistakable intent to annihilate rather than to simply kill. The manner of the attack revealed coldness, brutality, and a complete indifference to human life. Defendant then turned to Jennifer Canero. He shot Jennifer in the head, and while she remained alive, repeatedly stabbed her. The evidence established defendant inflicted multiple stab wounds after already delivering a catastrophic gunshot wound. Those additional wounds dramatically increased Jennifer's suffering and terror. The attacks were not instantaneous. Defendant prolonged the violence and inflicted repeated, penetrating injuries upon a woman already gravely injured. The repeated stabbing after the gunshot wound reflected rage, overkill, and extraordinary cruelty well beyond that was required to cause death. The violence inflicted upon Jesse and Sophia were even more horrifying in its cruelty and depravity. The evidence presented at trial established that these children desperately tried to flee from inside their home while the defendant hunted them with a knife. The crime scene reflected terror, panic, desperate attempts to escape, and attempt to protect their own lives. These children experienced imaginable fear in the final moments of their lives as their uncle relentlessly pursued and attacked them. Defendant repeatedly stabbed Jesse, The wounds were not isolated or incidental. They reflected a sustained and violent assault. Jesse suffered defensive injuries, establishing that he consciously attempted to protect himself from the defendant's attacks. Those injuries demonstrate that Jesse experienced the terror of fighting for his life while defendant continued the assault. Defendant nevertheless persisted, repeatedly driving the knife into a child attempting to survive. The brutality of repeatedly stabbing a child who is actively trying to defend himself demonstrates conduct that was especially cruel and depraved. The injuries inflicted upon Sophia were particularly shocking in both their savagery and force. Defendant stabbed Sophia through her nasal cavity with such violence that it fractured her sinus and penetrated her brain. Another stab wound pierced her chest cavity and collapsed her lung. That's what you did. These were catastrophic injuries inflicted with overwhelming force. The natures of the wounds demonstrated repeated acts of extreme violence directed at one of the most vulnerable victims imaginable. Defendant did not stop after inflicting lethal injuries, though. He continued the assault with a level of force and brutality that far exceeded that would have been necessary to cause death. Even after inflicting those devastating injuries, defendant abandoned Sophia inside the burning home. Rather than summon help or rescue, defendant left her lying helpless. Defendant left her lying helpless as smoke and fire consumed the residence over the course of hours. Sophia was left for dead with no ability to move. The medical evidence confirmed that smoke inhalation contributed to her death. Sophia's blood contained an extraordinary 49% carboxyhemoglobin level, demonstrating that she remained alive and continued breathing toxic smoke after suffering multiple catastrophic stab wounds. The suffering associated with those final moments of life is almost impossible to comprehend. Sophia endured devastating injuries while simultaneously inhaling poisonous smoke as the fire spread through the home around her. The image presented by the evidence is one of extraordinary cruelty. An injured child, mortally wounded and unable to escape, struggling to breathe while trapped inside a burning home after being brutally attacked by the defendant. The home, which should have represented safety and protection, instead became the setting for the prolonged terror, agony, and her death. As recognized in State v. Lewis, the painful and dreadful killing of a child by fire constitutes precisely the type of especially heinous and depraved conduct contemplated by aggravating factor number 1. The fact that the defendant inflicted injuries far beyond those minimally necessary to accomplish the murders strongly supports this factor. The fact that this defendant did more than was minimally required to satisfy an element of the offense may properly be considered under aggravating factor 1, even where the conduct overlaps with the elements of the crime. That's C. Cannell, New Jersey Code Annotated, Comment 3, NJSA 2C44-1A, also citing State v. Mara. In State v. Mara, the Appellate Division upheld a finding of aggravating factor 1 where the harm inflicted exceeded the single serious injury necessary to establish aggravated assault. 253 NJ Super, 557, 567 Appellate Division, 1996. Similarly, in State v. Fuentes, the Supreme Court discussed repeated stabbing, continued beating, and the use of excess force as conduct potentially supporting aggravating factor 1 when properly explaining it by the sentencing court. That's 217 New Jersey at 77. Here, the court has carefully evaluated all the injuries inflicted by each and every victim, both individually and collectively, the multiple gunshots to Keith, including the execution-style shot to the head, the gunshot wound to Jennifer's head followed by multiple stab wounds when she remained alive, the repeated stabbing of Jesse as he attempted to defend himself, the catastrophic stab wounds inflicted upon Sophia and her defensive wounds, and the additional suffering caused by smoke inhalation, and the fire demonstrated violence that extended far beyond what was necessary for the murder themselves. These acts were not merely intentional killings, they were executions carried out in an especially heinous, cruel, and depraved manner. The court therefore finds aggravating factor 1 fully applicable and affords it significant weight. The court also finds aggravating factor number 2. The gravity and seriousness of the harm inflicted on the victim, including whether or not the defendant knew or reasonably should have known that the victim of the offense was particularly vulnerable, or was for any other reason substantially incapable of exercising normal physical or mental power of resistance. Sentencing judges are instructed by the Supreme Court to examine the totality of the harm inflicted. State versus Kromhold, 162 NJ, 345, 358, 2000. In applying that case, the court focuses on Sophia's and Jesse's extraordinary vulnerability and their substantial inability to exercise any meaningful physical resistance during defendant's brutal attack. The evidence established that the defendant completely outpowered both children through his sheer size, strength, and possession of deadly weapons. Sophia stood only 4 feet tall and weighed approximately 45 pounds. Her stature was exceptionally small and thin. Jesse measured 4 feet 10 inches tall and weighed only 95 pounds. Defendant, by contrast, weighed approximately 230 pounds, stood 5 feet 11 inches tall at the time of his arrest. Defendant outweighed Sophia by approximately 185 pounds and outweighed Jesse by approximately 135 pounds. He towered nearly 2 feet over Sophia and a foot over Jesse. The disparity in size, weight, strength, and physical power between defendant and these children is staggering. Sophia and Jesse were innocent, defenseless, and obviously unarmed children. Defendant was a full-grown adult male armed with a knife. These children had absolutely no realistic ability to defend themselves, escape, or resist defendant's violent assault. State versus Pineda, 119 NJ 621, 628, 1990. The gravity and seriousness of the harm inflicted upon Sophia and Jesse cannot be overstated. Defendant exploited their complete physical vulnerability and used overwhelming force against children who were utterly incapable of protecting themselves from the terror and violence he unleashed. The attacks were not momentary or accidental. Defendant used a knife against 2 small children who faced a terrifying and hopeless situation against a much larger armed adult. Their vulnerability magnified the cruelty of the offense and the severity of the suffering inflicted upon them. Defendant's conduct also demonstrated profound cowardice. Rather than confront an equal, defendant chose to attack 2 exceptionally vulnerable children who posed no threat to him whatsoever. He used that overwhelming size, weight, strength, and possession of a deadly weapon to dominate and to terrorize children who were physically incapable of defending themselves. Sophia and Jesse were powerless against defendant's assault. Defendant preyed upon that helplessness and exploited it in the most brutal way imaginable. The court finds that the overwhelming imbalance of physical power combined with defendant's use of a deadly weapon against 2 defenseless children demonstrates an extreme level of brutality, cowardice, and helplessness that strongly supports this aggravating factor. And I give it significant weight. The court also finds aggravating factor number 3, the risk the defendant will commit another offense. When the sentencing court relies upon the risk of another offense, the court must identify particular facts supporting that finding. State versus Case 220 NJ 49, 66, 67, 2014. The court does so here. In State versus Verona, the Appellate Division upheld a finding that the defendant presented a risk of committing another offense, even though he had no prior criminal record. 242 NJ Super 474, 491, 492, Appellate Division, Certif denied 122, New Jersey 386, 1990. There, the defendant was an established businessman in a community. Yet, the discovery of a kilogram of cocaine in his possession demonstrated access to large quantities of narcotics and supported the conclusion that he would likely engage in future criminal conduct if permitted to remain free. 491. The Appellate Division nevertheless noted that the sentencing court in Verona afforded this factor only some weight. Similar to the defendant in Verona, defendant here has no prior criminal convictions. Unlike Verona, however, the facts supporting the risk of reoffense are significantly stronger, more disturbing, and far more compelling. The court does not base this finding upon speculation or generalized concerns. The court bases the finding upon the extraordinary level of planning, calculation, concealment, and sustained criminal conduct reflected throughout this case. These offenses were not spontaneous or impulsive acts committed in a moment of uncontrolled rage. Defendant engaged in a deliberate and methodical course of conduct that involved multiple weapons, multiple victims, and calculated efforts to destroy evidence and evade responsibility. Defendant armed himself and carried out separate acts of violence against 4 separate victims. After inflicting those catastrophic injuries, defendant set multiple fires through 2 different homes at 2 different locations, miles apart from each other, in an effort to conceal the murders and destroy evidence. The use of different weapons, the sequential nature of the attacks, and the deliberate acts of setting fires afterwards demonstrated organized, purposeful, and calculated criminal behavior. Defendant did not stop after the killings. The court finds that those facts critically important in assessing future dangerousness. They reveal a defendant capable of calculated violence followed by deliberate attempts to cover up his crimes. The sheer scope and complexity of defendant's actions strongly support the conclusion that he presents a continuing risk to society. Defendant demonstrated a willingness to commit extreme violence when it served his personal interests. He further demonstrated a willingness to engage in additional criminal conduct afterwards in order to conceal what he had done. The murders themselves are horrific. The calculated attempts to erase evidence through fire magnified the danger defendant presents. The danger defendant presents because they reflect planning, consciousness of guilt, and continued willingness to break the law to avoid accountability. Moreover, the jury here convicted defendant of theft-related offenses spanning over 2 years. Those convictions established that defendant engaged in an ongoing pattern of unlawful conduct long before the murders. State versus Locane, 454, NJ Super, 98, 121, Appellate Division, 2018. This was not an isolated lapse of judgment by an otherwise law-abiding citizen. The evidence demonstrated sustained, dishonest, and criminal behavior over an extended period of time. The murders themselves directly flowed from defendant's efforts to conceal and protect those ongoing illegal acts. Defendant's willingness to escalate from long-term theft and deception to calculated murder and arson demonstrates an alarming progression of criminal conduct. The court also finds defendant's complete lack of remorse highly significant. In State v. Rivers, the Appellate Division held that a defendant's lack of remorse properly supported aggravating factors 3 and 9. 252 NJ Super 142 153 Appellate Division 1991. Here, defendant has shown absolutely zero remorse for the murders of Keith, Jennifer, Jesse, and Sophia, and for burning down his own family's home, despite the avalanche of evidence. Defendant has failed to acknowledge the overwhelming and devastating evidence establishing his guilt. He has shown no compassion for the victims, no acceptance of responsibility, and no recognition of the suffering he inflicted upon the entire family, his own, and everybody else in this room. That absence of remorse matters because it demonstrates to this court that the defendant has not confronted the magnitude of his crimes or accepted responsibility for his conduct. A defendant who refuses to acknowledge overwhelming evidence even after conviction presents a greater risk of future criminal behavior because there is no indication of rehabilitation, insight, or moral reckoning. Instead, defendant's conduct reflects continued self-preservation and a denial in the face of catastrophic violence. The court therefore finds, based upon the particular facts in this case, that the defendant presents a substantial risk of committing another offense if given the opportunity. The prolonged theft-related conduct, the calculated and gruesome murders, the use of multiple weapons, the deliberate setting of fires to conceal the crimes, and defendant's complete absence of remorse collectively establishes aggravating factor number 3. The court affords this factor significant weight. The court looked at aggravating factor 4, 5, 6, 7, and 8 and find all of them to be inapplicable. Aggravating factor number 9, the need to deter this defendant and others from violating the law. This factor is applicable and also afforded significant weight. The court's determination or aggravating factor 9 requires a qualitative and net assessment of the risk of recidivism and also involves determinations that go beyond the simple finding of a criminal history and includes an evaluation and judgment about the individual in light of his or her history. State v. Thomas, 188, NJ 137, 153, 2006. Deterrence has been repeatedly identified in all facets of the criminal justice system as one of the most important factors in sentencing and is the key to proper understanding of protecting the public. State v. McGargle, 143, NJ 484, 501, 1996, citing State in the Interests of CAH and BAR, 89, New Jersey, 326, 334, 1982. Moreover, demands for deterrence are strengthened in direct proportion to the gravity and harmfulness of the offense. CAH 89 New Jersey at 337. For purpose of aggravating factor 9, deterrence incorporates two interrelated but distinguishable concepts, namely the sentence's general deterrent effect on the public and its personal deterrent effect on the defendant. State v. Jarbuth, 114, New Jersey, 494, 405, 1989. Cases where imprisonment for serious crimes will not further the goal of general deterrence are extremely rare, it at 408. At the same time, in the absence of a finding supporting specific deterrence, general deterrence has relatively insignificant penal value, it at 405. Accordingly, the sentencing court focuses on the need to deter the individual defendant from violating the law. The evidence in this case established defendant's conduct was calculated, organized, and purposeful criminal conduct extending over a significant period of time. As I mentioned, he engaged in the theft-related offenses over the course of nearly 2 years. Those ongoing criminal acts ultimately culminated in 4 murders, 2 arsons, weapons offenses, and hindering apprehension. The evidence demonstrated that the defendant committed these crimes to protect his own interest and ongoing illegal conduct. The nature of the crimes themselves powerfully supports both general and specific deterrence. Defendant murdered 4 people, including 2 children, through calculated and extraordinary violence. He used multiple weapons. He repeatedly shot and stabbed victims far beyond what was necessary to cause death. He then set fires throughout the home in an effort to destroy evidence and conceal the murders. These were not crimes committed in panic or confusion. Defendant made a series of deliberate choices before, during, and after the murders. Every stage of the criminal episode reflected conscious decision-making and calculating conduct. The need for general deterrence in this matter is overwhelming. Society must receive a clear and unmistakable message that calculated murder, the slaughter of children, and the use of arson to conceal crimes will result in the most serious punishment permitted by law. Crimes of this magnitude strike at the very foundation of public safety and civilized order. The brutal murder of an entire family inside their home creates fear far beyond the direct victims because it destroys the sense of security that every person should feel within their own residence. The law must respond forcefully to conduct of this nature in order to deter others who might contemplate resolving financial pressure, exposure, or personal problems through calculated violence. The court also finds an extraordinary need for specific deterrence. Defendant presents a substantial risk of reoffending for the reasons I've already stated. Defendant demonstrated a willingness to engage in sustained criminal conduct, escalate the conduct into calculated murder, and then commit additional crimes to conceal his actions. Those facts establish a profound disregard for human life, for our societal laws, and it is clear to me that he does not see that. Moreover, unlike the defendant in Jarbuth, defendant fully understood the nature and consequences of his actions. The evidence established planning, concealment, destruction of evidence, and efforts to avoid detection. Those acts demonstrate consciousness of guilt and awareness that his conduct was criminal. Despite the overwhelming evidence presented during approximately 5 weeks of testimony, defendant has shown absolutely zero remorse, no empathy, no acceptance of responsibility. While defendant maintains the constitutional right to remain silent and he asserts his innocence here, the court may nevertheless consider the complete absence of remorse in evaluating the need for deterrence. Defendant displayed no credible emotion or acknowledgement of the devastation he caused to 4 victims and an entire extended family. Defendant's own desires, decisions, and self-interest drove every stage of these crimes. The evidence demonstrates calculated choices, not diminished capacity or misunderstanding. Accordingly, the court finds a strong basis supporting both general and specific deterrence. For all of those reasons, the court finds aggravating factor number 9 fully applicable and affords it significant weight. The court has looked at the remaining aggravating factors and finds all of them inapplicable. The court will now balance the mitigating factors. In determining the appropriate sentence to be imposed on a person who has been convicted of an offense or offenses, the court must properly consider the following mitigating circumstances pursuant to NJSA 2C 44-1B. Number 1, the defendant's conduct neither caused nor threatened serious harm. Here, the defendant shot and stabbed 4 people to death while also putting his own family at risk of death. As such, defendant's conduct did in fact cause serious harm. Mitigating factor 1 is inapplicable. Number 2, the defendant did not contemplate that his conduct would cause or threaten serious harm. Defendant planned the murders in the hours leading up to leaving his house and when he left in his car in darkness to kill his family. He armed himself with a gun and knife and committed these crimes. He used a flammable liquid or gasoline to burn 2 homes. Mitigating factor 2 is inapplicable. Number 3, the defendant acted under strong provocation. There is no evidence defendant acted under any provocation. Factor 3 is inapplicable. There were substantial grounds tending to excuse or justify defendant's conduct through failing to establish a defense. That's mitigating 4. There is absolutely no excuse for defendant's heartless, brutal behavior. Mitigating factor 4 is inapplicable. Number 5, the victim of the defendant's conduct induced or facilitated its commission. There was no evidence that defendant's conduct was induced by any victim. All victims in this matter were defenseless. Mitigating factor 5 is inapplicable. Defendant has compensated or will compensate the victim of his conduct for the damage or injury that he sustained, or he will participate in a program of community service. Defendant can't compensate anybody in this case because he killed everybody in this case. Mitigating factor 6 is also inapplicable. Number 7, defendant has no prior history of delinquency or criminal activity, or has led a law-abiding life for a substantial period of time before the commission of the present offense. As I've mentioned, defendant has no prior criminal convictions, therefore the court will give this factor some weight. Number 8, the defendant's conduct was the result of circumstances unlikely to reoccur. Mitigating factors 8 and 9 are to be weighed against aggravating factor number 3, State versus Towie, the second, 244 NJ Super, 582, 593, 594, Appellate Division 1990. Since the court has afforded significant weight to aggravating factor number 3, mitigating factor 8 is also inapplicable. Number 9, the character and attitude of the defendant indicated that he is unlikely to commit another offense. Again, since mitigating factors 8 and 9 are to be weighed against aggravating factor 3, mitigating factor number 9 is inapplicable. I'm citing Towie at 593 and 94. Also, defendants are likely to get the benefit of mitigating factor number 9 when they show remorse, which is Rivera 249 NJ at 293 and 294. But a lack of remorse is sufficient to preclude this application. State versus O'Donnell, 117 New Jersey, 210, 216, 217, 1989. In this case, defendant has shown no remorse. Mitigating factor 9 is inapplicable. Defendant is particularly likely to respond affirmatively to a probationary treatment. Mitigating factor 10 is inapplicable because defendant has been convicted of a crime with a presumption of incarceration. State versus Scene, 443, NJ Super, 134, 144 to 145, Appellate Division 2015. Mitigating factor number 11, the imprisonment of the defendant would entail excessive hardship to the defendant or the defendant's dependents. Defendant has 2 adult children who do not rely on defendant for financial support. While it is always hard to lose a parent when there is a presumption of incarceration, there is nothing in the record to support this mitigating factor. Therefore, mitigating factor 11 is inapplicable. Mitigating factor number 12, the willingness of the defendant to cooperate with law enforcement. Defendant actively hindered the investigation, attempted to destroy critical evidence by setting fires to both residents connected to these offenses. Those deliberate acts of arson were calculated efforts to conceal murders, eliminate forensic evidence, and to obstruct investigators from uncovering the truth. Mitigating factor 12 is inapplicable. Mitigating factor 13, the conduct of a youthful defendant was substantially influenced by another person more mature than the defendant. That factor is inapplicable. Defendant was not under the age of 26. Mitigating factor 14 is inapplicable. And mitigating factor 15 only applies for offenses other than murder. He was charged with murder here, therefore it's inapplicable. Therefore, the court finds aggravating factors 1, 2, 3, and 9 giving each significant weight, and found only one mitigating factor, number 7, which the court gave some weight. The aggravating factors clearly and substantially outweigh the mitigating factors here. Now, before I impose sentence, I will also consider the doctrine of merger of some of these crimes for which the defendant was found guilty. The doctrine of merger, codified in NJSA 2C1-8A, governs whether multiple convictions arising from the same conduct may stand separately for sentencing purposes. The statute provides that although a defendant may be prosecuted for more than one offense arising from the same conduct, the defendant may not be convicted of more than one offense where 1 offense is included in the other, 2, one offense consists only of conspiracy or preparation to commit the other, 3, inconsistent findings of fact are required to establish the offenses, or 4, the offenses differ only in that one prohibits conduct generally and the other prohibits a specific instance of that conduct. A determination regarding merger must be made by the court after a verdict or finding of guilt. 2C1-8A. The doctrine of merger rests upon the principles that a defendant who commits a single offense may not be punished as though he committed multiple offenses for the same conduct. State versus Tate, 216, New Jersey, 300,302, 2013. Quoting State versus Davis, 68, New Jersey, 69,77, 1975. Convictions for lesser included offenses that are a necessary component of the commission of another offense, or offenses that merely offer an alternative basis for punishing the same criminal conduct will merge. State versus Brown, 138, New Jersey, 481, 561, 1994. In determining merger, the court also applies the flexible analysis articulated in Davis, which examines the time and place of each offense, whether proof of one offense is necessary to prove the other, whether one act formed part of a larger scheme, the defendant's intent, and the consequences of the criminal standards violated. That's Davis, 68, New Jersey at 81. The court finds that count 5 merges into count 3 and count 6 merges into count 4. Count 3 charges the defendant with murder of Jesse Canero. Count 5 charges felony murder of Jesse Canero during the commission of an arson at 15 Willowbrook Road. Count 4 charges the murder of Sophia Canero, and count 6 charges felony murder of Sophia Canero during the same arson. These offenses constitute alternative theories of liability for the same homicides. See State versus Brown, 138, New Jersey, 561. The offenses occurred during the same criminal episode, at the same location, and within a short period of time. Proof of the murders was necessary to sustain the felony murder convictions. Further, the felony murder counts form part of the larger scheme in which defendants set the resident on fire to ensure Jesse and Sophia would not survive. Because the offenses are substantially identical in both fact and law, separate convictions would violate the principles set forth in Davis. Accordingly, count 5 merges into count 3 and count 6 merges into count 4. The court finds that count 7, aggravated arson at 15 Willowbrook Road, does not merge. Once the felony murder counts merges into the murder counts, aggravated arson remains a distinct offense because proof of arson was not necessary to establish the murder convictions. Again, that's Brown, 138, New Jersey at 561. Count 8, aggravated arson at 27 Tilton Drive, defendant's own residence, also does not merge because it involved a separate criminal act committed at a separate location. The court finds that count 9, possession of a handgun for unlawful purpose, merges into counts 1 through 4. The jury instructions identified the unlawful purpose as defendant's use of a handgun against Keith Canero, Jesse Canero, Jennifer Canero, and Sophia Canero. The evidence did not establish any broader unlawful purpose beyond the murders themselves. Unlike State versus Diaz, when the only unlawful purpose in possessing the gun is to use it to commit the substantive offense, merger is required. That's 144 New Jersey at 636. Unlike State versus Tate, clarified that a weapon possession conviction merges when the evidence does not support another unlawful purpose for possessing the weapon. That's 216 New Jersey at 303. Because the state provided no broader unlawful purpose here, count 9 merges into counts 1 through 4. The court finds that count 11, possession of a knife for unlawful purpose, merges into counts 2 through 4. The jury was instructed the defendant possessed the knife for the purpose to use it unlawfully against Jennifer Canero, Jesse Canero, and Sophia Canero. The evidence established no broader unlawful purpose beyond the commission of those murders. Accordingly, merger is required under Diaz and Tate. The court further finds that count 12, unlawful possession of a knife, merges into count 11 pursuant to NJSA 2C1-8A1 because the elements of count 12 were subsumed within count 11. Counts 13, 14, 15, and 16. The court finds that count 13, theft of movable property, and count 14, misapplication of entrusted property, do not merge. These offenses involve separate conduct occurring over different periods of time and constituted distinct criminal acts from the homicide-related offenses. The court further finds that counts 15 and 16, hindering apprehension of oneself, do not merge into any other counts. Those offenses occurred at different locations and involved separate conduct from the murders, arsons, and theft-related offenses. Additionally, the elements of hindering differ materially from the remaining offenses. So therefore, the court finds as follows. Count 5 merges into count 3, count 6 merges into count 4, count 9 merges into counts 1 through 4, count 12 merges into count 11, and count 11 merges into count 2 through 4. The defendant will be sentenced as to count 1, 2, 3, 4, 7, 8, 13 through 16. The next analysis is whether the court will consider consecutive versus concurrent sentencing. NJSA 2C44-5A authorizes the court to impose multiple sentences either concurrently or consecutively with no outer limit on cumulation. Before making the determination, the court must sentence each offense individually, accounting aggravating and mitigating factors under NJSA 2C44-1A and 1B, and citing State v. Rogers, 124 NJ 113, 119, 1991. State v. Yarborough, 100 New Jersey, 627, 643, 644, 1985, establishes 6 guidelines. There can be no, number 1, there can be no free crimes. Punishment must fit the crime. 2, the court must separately state its reasons for imposing consecutive or concurrent sentences. Number 3, the court must consider facts relating to the crimes, including whether A, the crimes and their objectives were predominantly independent of each other, B, the crimes involved separate acts of violence or threats of violence, C, the crimes were committed at different times or places rather than so close in time and place as to indicate a single period of aberrant behavior, D, any of the crimes involved multiple victims, and E, the convictions were numerous. 4, there shall be no double counting of aggravating factors. 5, successive terms for the same offense should not ordinarily equal the punishment for the first offense. 6, cumulative consecutive sentences should not exceed the sum of the longest terms imposable for the 2 most serious offenses. State v. Carey, 168 New Jersey, 413, 423, 2001, reaffirmed the guidelines 2, 4, 5, and 6 address procedural requirements only. Guideline 1 tilts towards consecutive sentences because it focuses on the crime, not on the criminal. Guideline 3 is therefore the substantive deciding factor and must be weighed qualitatively and not quantitatively, it at 427. The court may impose consecutive sentences even when a majority of the Guideline 3 factors favor concurrent sentences. Crimes involving multiple deaths or serious bodily injuries are especially appropriate for consecutive sentences. That's Carey at 428. As to count 1, 2, 3, and 4, the 4 murders charged in this case, all Guideline 3 factors support consecutive sentences. Factor A, B, and C, the 4 murders were independent of each other. Each involved a separate act of violence by different means and in different locations. Defendant shot Keith Canero on the lawn, stabbed and shot Jennifer Canero inside the home, stabbed Jesse Canero with potential gunshot and smoke inhalation, and stabbed Sophia Canero and caused her death through smoke inhalation from a fire he set. Although the killing occurred within a compressed time frame, they were sufficiently distinct as not to constitute a single period of aberrant behavior. Factor D, there were 4 separate victims. Factor E, with 15 total convictions and 10 sentences to be imposed, the conviction count is numerous. Carey, 168 New Jersey at 424. Consecutive sentences are warranted when balancing the guidelines on all 4 of these counts for the murders, and that's carry at 428. As to counts 7 and 8, the aggravated arsons, count 7, the arson at 15 Willowbrook Road, runs concurrently. Factor A through D favor concurrent sentencing. The fire was sent contemporaneously with the murders, was closely intertwined with the course of conduct, and contributed to the 2 victims' causes of death. It did not constitute an independent criminal episode. Therefore, it will run concurrent. Count 8, the arson at 27 Tilton Drive, will run consecutively. That arson was independent under factors A through C. It occurred at separate locations after a break in the chain of events of driving from one crime scene to another. Factor D further supports consecutive sentences because it introduced 3 new victims, Caitlin, Marissa, and Susan Canero. Although Factor E favors concurrent sentencing, given the accumulating number of consecutive sentences, the separate location and new victims render this conduct a distinct criminal episode. Therefore, the guideline warrants a consecutive sentence. Count 13, theft. Count 13, theft, will run consecutively. The theft occurred in 2017 and 2018, well before the November 2018 murders, and constituted repeated, independent criminal conduct. Factors A, B, C favor consecutive sentencing. The theft's objectives were independent of the homicide and arson offenses, involved no acts of violence, and were so temporally removed as to not reflect a single period of aberrant behavior. Factor D marginally favors concurrent sentencing because the theft victims overlap the murder victims. Factor E also favors concurrent sentencing given the number of consecutive sentences already imposed. Nonetheless, there can be no free crimes, guideline 1, carry 168 NJ at 423, and the court may impose consecutive sentences even where a majority of factors favors otherwise, it at 427. 3 factors here favor consecutive sentences, and the theft is substantially distinct from the homicide and arson offenses, therefore a consecutive sentence is appropriate. Count 14, misapplication of entrusted property. That will run concurrent. It arises from the identical conduct from count 13, misappropriation of funds from Keith Canero's trust at the same time in the same location with the same victims. All guideline 3 factors favor concurrent sentencing, and running it consecutively would impose multiple punishments for a single criminal act. Counts 15 and 16, the hindering. Count 15 related to hindering apprehension related to the murders. Count 15 will run concurrently. Defendant attempted to destroy bloody soaked clothing after the murders by setting it on fire. Factor A, the offense was not independent of the murders. Factor B, the conduct was identical to the arson. Factor C, it occurred contemporaneously with and at the same location as the arson. Factor D, the victims were the same as the murder victims. Factor E, a consecutive sentence would push the total towards the numerous range. A majority of these factors favor concurrent sentencing. Factor 16, hindering apprehension related to the theft of misapplication, of entrusted property will also run concurrently. Defendant committed these offenses in furtherance of counts 13 and 14 by forging documents and stealing from Keith Canero's trust. All guideline 3 factors favor concurrent sentencing. Factors A, B, and C. The offense was not independent and it was committed in furtherance of the same course of conduct. Factor D, the victims were the same. Factor E, a consecutive sentence would further approach the numerous range. With that said, the court finds as following. Count 2 runs consecutively to count 1. Count 3 runs consecutively to count 1 and 2. Count 4 runs consecutively to counts 1 through 3. Count 8 runs consecutively to the aggregate of counts 1 through 4. Count 13 runs consecutively to the aggregate of counts 1 through 4 and 8. Count 7, 14, 15, and 16 run concurrently with the aggregate consecutive sentences. So with that being said, the court will impose the following sentence. Under Indictment 19-02-0283, Count 1, charging you with murder in violation of 2C 11-3, I sentence you to the custody of the Commissioner of the Department of Corrections to life with no possibility of parole. This was a Graves Act offense. There's a $100 VCCO penalty, a $75 safe neighborhood assessment penalty, and a $30 law enforcement trading fund penalty. You have 2,745 days of jail credit. As to Count 2, charging murder in violation of 2C 11-3, a first-degree offense, I sentence you to the custody of the Commissioner of the Department of Corrections for life without the possibility of parole. Again, to run consecutive to Count 1. This is also a Graves Act offense. There's a $100 VCCO, $75 safe neighborhood assessment penalty, and again, the same jail credit. Count 3, charging you with murder in violation of 2C 11-3, a first-degree offense. I sentence you to the custody of the Commissioner of the Department of Corrections for life with no possibility of parole. There's a $100 VCCO penalty and a $75 safe neighborhood assessment penalty. Count 4, charging you with murder in violation of 2C 11-3. I sentence you to the custody of the Commissioner of Department of Corrections for life without the possibility of parole. That's a $100 VCCO penalty and a $75 safe neighborhood assessment penalty. Again, each one of those are consecutive to each other. As to Count 7, aggravated arson in violation of 2C 17-1A, a second-degree offense, I sentence you to the custody of the Commissioner of the Department of Corrections for a period of 18 years, subject to the No Early Release Act, which means that you must serve 85% of that 18-year sentence. There's also, on that offense, because it's a nearer offense, even though it's inapplicable, you would have a 3-year parole supervision if you were released, but that will never happen in this case. There's a $100 VCCO penalty, a $75 safe neighborhood assessment penalty, and again, the same jail credit. The reason why for the $100 VCCO there is because that is for the Colts Neck residents. Count 8, aggravated arson in violation of 2C 17-1A, a second-degree offense. I sentence you to custody of the Commissioner of the Department of Corrections for a period of 18 years, subject to the No Early Release Act, meaning that you have to serve 85% of 18 years before you be eligible for parole. That is run consecutive to the 4 life terms that I just gave you. There's a $50 VCCO and a $75 safe neighborhood assessment penalty. Again, the same jail credit. As to Count 13, theft in violation of 2C 20-3, a second-degree crime, I sentence you to the custody of the Commissioner of the Department of Corrections for a period of 18 years. There's a $50 VCCO and a $75 safe neighborhood assessment penalty. Again, so that will run consecutive to the 18 years I gave you on the arson and also the 4 life terms that I've given you. As to Count 14, misapplication of entrusted property in violation of 2C 21-15, a second-degree crime, I sentence you to the custody of the Commissioner of the Department of Corrections for a period of 18 years. There's a $50 VCCO, a $75 safe neighborhood assessment penalty, and that will run concurrent to Count 13. Count 15, hindering your own apprehension for the murders in this case, in violation of 2C 29-3B1, a third-degree offense. I sentence you to custody of the Commissioner of the Department of Corrections for a period of 4 years. There's a $50 VCCO, $75 safe neighborhood assessment penalty. Again, that will run concurrent with the same jail credit. Count 16, hindering apprehension, dealing with the theft and the misapplication of entrusted property. In violation of 2C 29-3B1, a third-degree offense, I sentence you to the custody of the Commissioner of the Department of Corrections for a period of 4 years. There's a $50 VCCO, a $75 safe neighborhood assessment penalty. Again, that is to run concurrent on all counts. Today, defendant's greed, manipulation, and selfish conduct ends. His address will forever be the Department of Corrections. His only reality is confinement, consequence, and accountability. Punishment is paramount, and the court imposes it without any hesitation. While defendant will not acknowledge his behavior and wrongdoing, a jury of his peers did. And this court now imposes a sentence that fully reflects the verdict and the gravity of these offenses. Although more than 7 years passed before this matter reached trial due to COVID, pretrial litigation, and the complexity of these proceedings, justice delayed is not justice denied. You are no longer Paul Canero. You are an intimate number in the Department of Corrections. You are a quadruple murderer who slaughtered innocent children. That is your identity. That is the identity you will carry for the remainder of your life behind prison walls, confined to a 4-foot by 7-foot cell until your final breath. That's the sentence I'm imposing. You have 45 days from today's date to file an appeal of this sentence. If you miss the 45-day deadline, you can get a 30-day good cause extension if you can show good cause. If you cannot show good cause, you can be losing your right to an appeal. You also have 5 years from today's date to file a post-conviction relief. I have the appeals right form that has been signed by the defendant and by Ms. Mastalone. Prosecutor, anything else? You can.
Please continue.
Does the state have anything to add?
Sentence that was just imposed, the state moves to dismiss indictment 1907-1038.
That will be dismissed. Thank you all.
Thank you.
I think we're going to go right down
Hello everyone, that was the sentencing and of the Kinerio defendant. So it ended about 25 seconds ago. I think the judge did it right. At this point in time, I'll play see if the Ebony trial's on. I know that was being talked about before. You wanted to see that. My pleasure. Okay, you got her right here. Copy link right here, and let's drop this right now. All right, here. This is the Ebony trial.
Well, it wouldn't be hearsay if they were not offering it for its truth. So
Then how's it relevant?
it's relevant because it shows Dr. Parker's knowledge.
Which goes to an element of the case.
Yes.
And therefore it has to be reliable. So what hearsay exception is that? What case law do you have? What authority allows that to come in?
Judge, if it is hearsay, if the court's ruling is that it is hearsay, it does not come in.
Okay, and hearsay is common. So you all do not consider that. Next question.
Thank you, Judge. So, Ms. Werner, I'll back up a little bit. You mentioned that you were were you personally in the cafeteria?
I was.
Okay. And was there anything you personally observed about JT that concerned you?
Yes. I was speaking with a security officer in the cafeteria about something, and at that same time, I witnessed the student was staring her down, very focused on her, and he slowly got up from his seat and ever so slowly approached, still not breaking focus or eye contact at the security officer, and that stuck out to me a lot as well.
Okay. And is it fair to say that you do go to Dr. Parker to report concerns?
I do.
And without telling us what anyone else said, did you relay to her concerns that about things you had observed and concerns about that had been told to you by others?
Objection, Your Honor.
I don't know what the objection is.
That would be hearsay also.
Did you observe?
She's reporting what she observed. The report is hearsay. It's an out-of-court statement, out-of-court truth, Your Honor.
Okay, your response, Mr. Chairman.
I am only offering that she informed Dr. Parker of her concerns and that her concerns were based on both her observations and what others had told her. I am not eliciting what others said to her at all, so it's not hearsay.
Not the statement, just the, okay. So, overruled, ask your question again. You may answer.
All right, so Ms. Werner, did you eventually go speak to Dr. Parker about your concerns?
I did.
And did those concerns include both your observations and what others had said? Don't tell us what the others said, but just did your observation, did you report to her the problem?
Yes.
Okay, tell us what you reported to Dr. Parker.
Your Honor, I'm going to continue my objections because this question was what she observed and what others said. Now he's going to ask her what you reported, and so she's reporting, sounds like hearsay.
Response.
Judge, she is reporting to Dr. Parker concerns she has based on a totality of things that include what others have said to her. I'm not eliciting what others said to her. I am eliciting what she told Dr. Parker. That is what the testimony is. So this is not hearsay. I am not offering the statement of those individuals at all. Even if I was, I wouldn't be offering it for its truth. I'm offering it for Dr. Parker's reaction to her response. So it is not being offered for its truth. It's being offered for her state of mind.
So I'm going to sustain in part and overrule in part. again, if the hearsay can't come in through the front door, it then cannot come in through the back door by her saying, well, this is what I told her based upon what other people told me. So she can answer your question as to what she told Dr. Parker based upon her personal knowledge and personal observations, but she cannot relay what she told her based upon what other people told her. So you can proceed that way.
I don't know any other way to ask this, but what did you tell Dr. Parker?
I told her specifically that the student seemed to be off already that day and in a violent mood.
Okay. At some point during the course of the day, did anyone suggest to you that that same student, JT, might have a gun?
Yes.
Objection. Hearsay.
Okay, objection, hearsay, and maybe foundation. Your response, Mr. Jenkins.
So first of all, that also is not being offered towards truth. We're not offering it to prove that JT had a firearm. We're offering it to prove that someone informed her of a danger, so it's for her response.
So can you lay a better foundation as to how she would have this knowledge?
Sure. During the course of the day, did you become aware that a child was armed?
Yes.
And is that because someone told you the child was armed?
Yes.
Who told you that?
Our reading specialist, Amy Kovac.
Your Honor, I'm sorry. I was distracted. He asked two questions when I did not hear what those questions were, so I want to make sure that I understand what the questions were. So,
Okay, Mr. Jenkins, if you would please repeat, or did you ask your co-counsel?
we were actually talking. So,
Okay, he asked, how did you find out he was armed and who told you?
okay. Objection, hearsay. Honest.
Overruled. Go ahead, Mr. Jenkins.
At that point, what was your state of mind as to...
Sorry, so that was the question. I did not hear what her response was to that question.
Oh, she said Ms. Novak told her. I've got your objections on the record. Overruled. Start your question over again, Mr. Jenkins, please. I believe you said, what was your state of mind?
Yes. What was your state of mind as to concerns about that being shared with administration? Were you going to go share it?
Was I? No. Ms. Kovac went and told administration.
And
Objection, hearsay.
Continued objection noted. You may proceed.
And as to that objection, it is overruled, Judge.
It is overruled. Yes,
Thank you.
may proceed.
After that point, were you concerned enough to keep a close eye on JT?
Yes.
Tell us about your observations going forward from there.
Specifically what point in time?
Yeah, so at some point, do you end up, your class goes to recess?
Yes.
Are you there?
Yes.
Okay. What did you observe at that time, if anything, that was concerning?
Yes. I noticed that the student was wearing an oversized jacket with both of his hands in his pockets that remained in his pockets the entire time.
Okay.
And that stuck out to me.
Okay. Did you report that observation to anyone?
I texted Amy Kovac
Okay.
that observation.
Okay. After recess, did there come a time when JT and your whole class and you were back in the classroom?
Yes.
And did you observe anything that concerned you when you're back in the classroom that day?
Yes.
tell us what you observed back in the classroom that started to concern you.
Specifically,
So did you observe JT doing anything that made you concerned once after recess time and you're in the classroom?
I went up there to leading the witness.
Judge, if I may respond to that.
You may respond.
So a closed-ended question where the witness can answer yes or no is not inherently leading. A leading question is one that suggests one of those two answers is the right answer. I am merely trying to direct the witness to where and when I'm talking about. So in another sense, it is just a preliminary matter. I am not, trying to use it to get a specific answer from her.
Anything further, Mr. T?
Yes, Your Honor. And I think he's actually been leading for quite a while.
He has, but you didn't check him. No, this one wasn't leading, so I'm going to allow it overruled. But some previous ones were leading, so we'll try to contain that. Do you, the witness, do you need him to repeat the question?
yes, please.
Okay. I just want you to describe any concerning observations about JT that happened in your classroom after recess,
If any.
if there are any.
Both hands remained in his pocket, his oversized jacket the entire time.
Was he wearing the jacket in your classroom?
Yes.
Okay.
Did not remove it after recess.
So, Mr. Werner, at some point in the day, were you injured?
Yes.
Tell us what immediately precipitated that. Describe it for us.
It came to where I saw out the corner of my eye, my peripheral, the student had. I saw the student looking at me. I looked over. A gun was pointed right at me. He was holding a gun, the student. It was pointed right at me, and then I was shot.
And where on your body did a bullet strike you, if it did?
It went through my left hand and into my chest.
What did you do from there?
I recall the children were getting out of the classroom. Miss West was across the hall. She opened her door and was helping the students. And I went to the office.
Okay. At the moment the gun is fired, and I am asking you to estimate how many children were in your classroom. I'm not asking her to speculate about it. I'm asking her to give us a range that it could have been at the time. She doesn't have to guess. She was there.
Overruled. You can answer.
I would estimate, I would say it's most likely the same as before, but estimate on the lower side, I was missing a couple of students that day. Around 20.
Okay. Thank you. You've described the moment where a gun is pointing at you. At that moment, are there any children in your field of vision?
Yes.
Could you describe that?
It's in, the time is in the middle of class, in the middle of a small reading room. So I have students nearby. I also have students at their desks. I have the students very close.
Were there any students that were within inches of JT?
Yes.
Were there any students that were between you and JT?
I don't recall.
Okay. May I have a moment, Your Honor?
Yes, sir.
That's all the questions I have for you now. Please answer any questions from the defense counsel or the judge.
If I may.
You may.
Thank you. So basically, JT was in your class on January 6th, is that correct?
Yes.
Okay. You reported that he was a little off the chain, being a little violent that morning, is that correct?
He appeared to be off and seemed to be in a violent mood.
Okay. And you had some contact with Ms. Kovac, is that correct?
Yes.
Okay. And you had contact with Ms. Kovac before you went out to the playground for recess, is that correct?
Yes.
Okay. And on direct, you said that Ms. Kovac told you that JT was armed, is that correct?
She told me that the student had told other students that he had brought a gun with him.
That wasn't your testimony on direct. You said that Ms. Kovac told you that he was armed. That was your testimony, is that correct?
Here today?
Yes.
I said that. No, I'm sorry if I said that. I was specifically told that he was telling other students that he brought a gun with him.
Your Honor, sorry. So now I'm going to.
I might have heard the question a little differently in my mind.
I know this is the cross-examination, but I'm going to renew my objection to that response because clearly now she's referring to hearsay, and I'm going to ask that her answer to Mr. Jenkins be struck.
Okay. At this time, we'll have a response.
Your Honor, this information is being used to show why Ms. Warner took the action she did, not being offered for its truth. And hearsay is only hearsay if we're offering it because the statement made is true. So it explains the actions that she took. It is in part a present sense impression if the court is going to rule that it's hearsay, because she's describing a condition that's occurring right now while it is ongoing, and it is being offered to show how they respond to it. Counsel is objecting to me eliciting hearsay and then standing up and eliciting hearsay. And she gave a short answer to me because we were narrowed by the hearsay objection. She was explaining it more fully to counsel now because he asked. So he elicited the hearsay this time. So he can live with that. The rule is that hearsay is an out-of-court statement being offered for its truth. We're not offering any of these statements to prove that JT had a gun. We all know he had a gun. We'll have that testimony. We're offering the statements to establish why these people took the actions that they took. That's it. That's not being offered for the truth.
Anything else, Mr. Brown?
I will submit, Your Honor, it is exactly being offered for its truth. Her statement, which I just basically just wanted to clarify, her response to his question, she said he was armed. And so, and she wanted to further elaborate. Her elaboration, had she elaborated during the first question, I would have objected. Clearly hearsay, she's repeating something that somebody else told her. It's hearsay upon hearsay, Your Honor, and it's definitely being offered for its truth, because there would be no need to respond if there was not a gun.
So for consistent and clear ruling, again, it came in before, I'm going to allow the statement in. This is a classic example of why we have cross-examination, and all three attorneys are wonderful attorneys who will flush this out for the jury, and we can have an instruction later, again, that it is not for the truth of the matter, but to explain why the person did what they did. So again, you may continue with your cross-examination, and the jury can consider the responses ultimately the ruling. The current objection to exclude it based on hearsay is overruled. Please proceed with your cross-examination.
Thank you, Your Honor. So, based on information that you received from Ms. Kovac, you believed that the student was armed. Is that correct?
It crossed my mind, yes.
Okay. So it crossed your mind that he had a gun. Is that correct?
When I was told what I was told, it was possible.
Okay. So if he was armed, that presented a danger to your students. Is that correct?
Yes.
Okay. So you took no action to separate JT from his other classmates. Is that correct?
Yes.
All right. And so you allowed him to go out to recess with the understanding that he may have had a gun. Is that correct?
Yes.
You could have refused to let him go to recess. You could have removed him from the presence of his other classmates. Is that correct?
In hindsight, yes, I could have.
Okay. And then you allowed him to return to your classroom with the other students. Is that correct?
Yes.
Okay. Nothing prevented you from excluding him from the classroom. Is that correct?
Yes.
Okay. And nothing prevented you from actually taking JT out of the classroom and taking him down to the administrative office. Is that correct?
Yes.
Okay. So on Wednesday, JT was being disruptive, and you did take him out of the classroom. Is that correct?
Yes.
Okay. And you also alerted administration. Is that correct?
Personally, no.
Okay, but you took steps to make sure that the administration was notified. Is that correct?
Personally, no.
You did not take any steps to make? Okay. All right. You would agree that the potential that there's a firearm in the classroom is a lot more serious than JT breaking a cell phone. Is that correct?
Yes.
All right. You didn't, once you became concerned, aware of a potential of there being a firearm in JT's possession, you didn't personally let the administration know that I believe that he has a gun. Is that correct?
Correct.
Okay. You personally did not call the police. Is that correct?
Correct.
You personally didn't ask anyone else to remove JT from the classroom. Is that correct?
Correct.
You would admit that the person that has the first responsibility to protect the students in the classroom is you as the teacher. Is that correct?
Correct.
And you would admit that you did not take any steps to protect the students from JT, in your words, potentially being armed with a firearm. Is that correct?
I would not admit that.
Okay. What actions did you take to protect the students from JT having a firearm?
This might cross the rules of hearsay, I'm unsure. But from the knowledge that I had that day, I was aware that she was told by other coworkers.
I'm talking about what you did.
Absolutely.
What actions did you take?
Absolutely.
All right, your response is absolutely?
I'm sorry, what was the question? The full question?
Okay. What actions did you personally take to protect the students in your classroom from JT being potentially armed?
I trusted my colleagues.
Okay. All right. Your Honor, can I have a moment?
You ready? And while we're doing so, the juror right under that skylight, if you want to move to the empty seat, you can. I apologize. If you're okay, you can stay. There's nothing I can do about it.
Thank you, Your Honor.
Okay.
I'll get it out.
Okay, all right. I just want to let you know if there is an empty seat, if you'd like to move.
Well, let me ask, Your Honor, if you ask the defendant's counsel to speak a little bit closer.
Speak a little loud. We can do that. Thank you. And if you follow instructions, yes, if you can't hear it, let me know. We can fix that. All right. So, Mr. Rogers, you heard that instruction.
I did.
Project.
My apologies. I'm a soft talker. So, all right, Your Honor, that's all the questions I have for this witness.
Oh, thank you. And you read it back.
Yes, Your Honor.
Just briefly, Ms. Werner, while you were at recess, were you observing the student closely?
Yes.
Did you have a belief about someone at that time, while you're at recess, going and reporting the issue?
Objection to leading, Your Honor.
Okay, response.
I said, did she have a concern? It is a yes or no question, but that does not make it leading. I'm not suggesting that the answer would be yes or no. I'm just...
Okay, Mr. T, can you flesh out the objection of what part of the question is leading?
What I heard him ask is, did you have an understanding that someone had gone to speak with Dr. Parker while she was at recess? I mean, I think he's leading her testimony there.
And what was your question again, Mr. Jenkins?
Did you believe that while you were at recess watching, do you believe that someone was reporting what you were seeing with JT, the concerns about JT?
And that's the question that you're objecting to leading?
Yes, Your Honor, because she has not testified to any such thing, and so he's leading her to it, and to actually try to testify on her behalf.
Okay. Overruled, I'll allow it, but there may be another objection coming because we need to establish foundation for this belief. Okay, but go ahead for now, Mr. Jenkins, I'll give you some leeway.
Have you told someone that there was an incident that should be reported to Dr. Parker?
Your Honor.
Hearsay objection.
So,
Okay, and I understand. And Mr. Jenkins is saying, well, how can I lay my foundation if you keep not letting in the hearsay? I'll allow it. Go ahead. It's not for the truth of the matter asserted. It's to explain the actions of why the person takes the actions that they take. Go ahead, Mr. Jenkins.
Ms. Werner, I'm not even asking what you said. I'm merely asking, did you report concerns to another person about JT around the time of recess?
I did directly to Amy Kovach.
Overruled. But go ahead. Repeat your answer. So he asked you, did you report? What was your answer?
I did directly to Amy Kovach.
And then did you continue to watch JT?
I did.
Okay. What was your understanding of the teacher or faculty member role in the event of an emergency or crisis at that time?
My understanding from it was being brought up to administration. I'm not sure how much what sentence to put that in when
Ms. Werner, are you worried right now about the rules of evidence and hearsay? Because, okay, I don't want you to worry about that. The judge and the lawyers will worry about that, okay? You don't have to. All you need to do is give an honest answer. So, I'll repeat the question. Okay. What was your understanding of a faculty member's role when you learned of a crisis? What was your understanding of what you were supposed to do?
Report it.
Okay, great. Thank you. I don't have anything further, Judge.
Recross?
Just,
Yes, sir.
but it was also your understanding as a faculty member or teacher that you were responsible for the safety of your children. Is that correct?
Yes.
And that if there was a threat of danger to your student, you were supposed to remove that danger or threat from the presence of the student. Is that correct?
Yes.
Thank you.
Anything else for this witness?
No, Your Honor.
All right. And does she remain or may she be excused?
Your Honor, we're asking that for all of our witnesses, we're asking they be constructively sequestered, told that they need to not discuss the case with anyone, and potentially be recalled, but to be able to leave the courthouse.
Your position.
We've also, she's been from the defense, and we've asked that she remain.
Judge, if I may address that.
Okay.
We have many witnesses here. We don't need to keep them here for all 3 or 4 days. I've told all of the witnesses they're subject to being brought back to court, and I have all of their phone numbers. And if Mr. Rogers wants them to come back, I will cooperate and ensure that they are back here and provide any contact information that's needed. But I don't want to keep people here for 4 days if they don't have to be.
Understood. So almost agreeing to them remaining sequestered, but that they can leave the building and they're on call to be brought back. Your position.
That's fine.
That's fine. Okay. All right. So, Ms. Warner, those are your instructions. You may step down from the witness stand. You may leave the building, but you may not discuss the case until this trial has concluded. And they have your phone number, so they'll call you when we need you to come back. All right. Thank you very much. Okay. And we've been out for about an hour. Can we take maybe a 10-minute break, and then we'll start with the next witness?
Yes, Your Honor.
Thank you.
Okay. And let me see. It's 10:49. We'll resume at 11 a.m. Thank you all.
Leave your books right there on the floor in front of your chair. You're not picking up the desk. Please do not pick up the desk.
All right, we are now resuming the case of Commonwealth versus Parker. All counsel are in place as defendant. We're going to bring the jury back out. Please, Sheriff. Thank you.
Please stand for the jurors. Jurors in the box. You may be seated.
We're going to resume testimony. It's around 11 a.m. And for parties time-wise, I probably will try to break for lunch around 1. Okay, so we're going to keep going until 1, but if anybody needs a break, I don't mind. We'll take a break. Just let me know. All right, next witness.
Commonwealth calls Amy Kovac.
Okay. Amy Kovac, and I'm saying
K-O-V-A-C.
Thank you.
Here, face the clerk. Raise your right hand.
Do you swear or affirm that testimony you're about to give is the truth, whole truth, and nothing but the truth? Thank you.
You look up on a second. You watch this step now. Right, rotate.
Good morning. If you can move the microphone if you need to. Okay. And please answer questions the attorneys may have. Okay.
Good morning. Could you please tell us your name?
Amy Kovac.
Could you spell your last name for us?
K-O-V-A-C.
Thank you. Ms. Kovac, how are you employed as of today?
I work with Newport News Public Schools as a reading specialist at Newsom Park.
All right. And then I want to take you back to January of 2023. Were you also a reading specialist at that time?
Yes.
And where were you working?
Rich Neck Elementary.
How long have you been employed as a reading specialist total?
12 years total.
During your time at Rich Neck, did you know a student, and I'll remind you that we're not using any student names, so please keep that in mind, but did you know a student by the initials of JT?
Yes, I did.
How did you come to know JT?
Dr. Parker, at the time, had put him on a modified schedule, and I was his one-on-one teacher for reading during that scheduled time.
Okay. Do you know from your own observations and interactions why JT was on a modified schedule?
I had heard he had... I was on the modified...
Hold on one second. Let's go back one. And how this works procedure-wise is they object, the other party gets to respond, and then I'll make a legal ruling, and then I'll let you know what to do. So, and just explain it to you. Okay, so the defense is objected. Your response, Mr. Jenkins.
Your Honor, if there is hearsay there, I'm not trying to elicit that, so I'll try to rephrase the question.
Oh, yes, sir.
Ms. Kovac, did you have any personal interactions with JT yourself that led you to believe that he needed a modified schedule?
Not before the modified schedule.
Okay, understood. So you started working with him on a modified schedule. When was that?
It was in early October.
And tell us a little bit about how the schedule worked.
So Originally, the schedule, he would come to school at 9:20, get off the bus, and our counselor, Mr. Rawls, at the time would pick him up off of the bus and get him breakfast and set a goal for his day. And then he went down to Mary McBurnett, our K2 special ed teacher, where she was to do a social story. And then he was to come to me around 9:30 or 9:45 and for like 15-20 minutes do reading with me, and then Mr. Rawls would take him into Ms. Warner's classroom, and then he would leave around, I think, like 10:40, 10:45, get his lunch and then go home.
And you've mentioned Mr. Rawls. Do you know what his title was there?
He was the school counselor.
Okay, thank you. I want to speak to you about the morning of January 6, 2023. Did there come a time when you were in the office that day with Abigail Zwerner and Dr. Parker?
Yes.
And while you were in that office, did you, based on what you heard in that office, did you have concerns?
Yes.
Later in the day, did you tell Ms. Zwerner to keep an eye on JT?
Yes.
Why?
Because 2 girls had reported to me that he had a gun in his bag.
Okay, what's your objection?
May I lay a foundation for the potential use of an exception, Judge?
Okay, yes, sir.
You've indicated, I believe, that 2 girls spoke to you. We'll hold off on what they told you. Can you describe those girls' demeanor or behavior at the time they're reporting it to you?
Yes, I was walking past the room and the 2 little girls had come out to me and said that JT...
Oh, wait, hold on. Before you tell us what they said, what I want to know is how they appeared to you.
They seemed to be scared and worried.
Okay, what did you see in them, what in their bodies or their faces that made you think that?
The actions of them coming close to me, wanting to get my full attention and to let me know, and their faces were kind of like expressive to show worry and concern.
Okay, and eventually they do tell you something, again, without going into what they said. Do they relate to you about something that has just happened, that they've just seen in the minutes before? This is to establish a foundation to use a hearsay exception, Judge. It's
okay, so
foundation.
Hold off on answering. Let me hear the full question, then I can decide on the objection.
Yes, the question is whether the report she receives is quick in time to when she received it. In other words, whether they are reporting something that happened within the last minute, because that's a foundational question for the excited utterance exception.
Mr. T.
Yeah, I think that's clearly reading. He's asking for, she has not even testified anything about what they said or how, she testified that they seemed scared or whatever, but he's giving her the answer by asking that her, did they tell you something that had just happened right before you came in contact with them? I mean, that's his testifying to the witness.
Okay, well, let me pull out the excited utterance.
Rule 2803-2.
Rule 2803 of the Rules of the Supreme Court of Virginia reads, excited utterance, a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with first-hand knowledge at a time and under circumstances negating deliberation. All right. Mr. Jenkins, I'm going to have to sustain the objection because she's not the declarant according to the rules. The declarant would be purportedly that child.
Judge, could we address this matter outside the presence of the jury, please?
We can. You want to meet me in the jury room or sidebar? I would like to address it.
If we can address it on the record, it doesn't matter to me.
Okay. So members of the jury, sometimes you get more steps in than you wish. I'm going to ask you to retire to the jury room, please, and I'll take up this objection.
I'd ask that she go into the witness room.
Okay, and one moment, Ms. Kovac. We'll wait for the bail to come. I'm not sure that door shouldn't be locked, but we'll wait. Okay, members of the gallery, you can have a seat. Okay, Sheriff, we're going to have Ms. Kovac step back into the witness room. Watch your step, please. Okay, yes, sir.
Judge, I'm sorry. Were you recognizing defense counsel or
No,
defense?
Okay. You wanted to take this up?
I do.
So the objective, and yes, your response.
I do. There are two things going on here, Judge. The first is that in an effort to keep things moving, I was asking foundational questions about the excited utterance exception, and if counsel prefers, we can do that as a voir dire of the witness outside the presence of the jury, because whether the excited utterance exception applies or not is a matter for the court and not the jury. So perhaps it would have been more appropriate for me to ask the foundational questions outside the presence of the jury. But regardless, in order to establish the foundation for any hearsay exception, I'm going to have to ask leading questions. So that is why it is usually not done in front of the jury, that we do that outside of their presence. As to the excited utterance, and I will request a moment to pull up some cases, but the rule reads, a spontaneous or impulsive statement prompted by a startling event or condition made by a declarant with first-hand knowledge at the time. When the rule says a declarant, it is not referring to the person on the stand, because then they would be here, the declarant would be here. The rule is referring to hearsay, that is the person on the stand reporting what they were told, but the declarant in this case is the girls. They are making a statement that is about a startling event or condition made by them, the declarant, at a time when they were still under the circumstances negating deliberation, because, as I was asking when counsel objected, how quickly were they reporting it? Were they reporting something that happened a year ago, or were they reporting something that happened in the last minute? That was the question I was getting at, to determine whether the statements the girls made to Ms. Kovac were spontaneous. Ms. Kovac is the person in court today, but she's not the declarant for the purposes of the rule. The declarant is the out-of-court statement. And so if I may have a moment to find a case example, I think I will be able to.
Okay, you may, and I understand your argument, there's a distinction between a declarant and the declarant. And I'll give you a moment to find the case, but projecting this forward, how are you going to lay a foundation of how she would know how soon their statement was made to when the children observed whatever concerned them to when it was relayed to Ms. Kovac? Because you brought that up. But do you have a plan to flush that out?
I think we should flush that out before we bring the jury back in.
Right. So that's what I'm
yes.
asking. So just thinking forward, that will come next. But yes, I'll give you a moment.
Yes.
Okay, just let me know when you're ready. Hold on to the fence. Let us find this case. and then I'll happily hear from you.
Can I step out while he's finding the case?
Sure.
Thank you. What's the case?
One of them is Hicks v. Commonwealth.
What's the side?
60 VA App 237.
60 VA App 237.
Yes.
Could you give me a moment just to look at that before we start?
Sure.
Do you have a case, Mr. Rogers?
I do. I'm trying to just read it so I can.
Okay, well, we're going to move on. Go ahead, but we're going to have to do two things at the same time. Yes, Mr. Jenkins.
Yes, Your Honor. The case that I would cite for the court is Hicks v. Commonwealth, HICKS. It is 60 Virginia App 237, May 29th of 2012. I cite the case only because it is an example where a witness is on the stand and is allowed under the excited utterance exception to testify that the victim of a shooting said he'd been shot. So the declarant in that case was the victim who had been shot, excitedly declaring something spontaneously, while the witness in court was someone else entirely who just heard the out-of-court statement. That's what we have here. Ms. Kovac has heard, I believe we can do voir dire to ensure, has heard an excited utterance from these two children, and they are the declarant that the rule contemplates.
Yes, Your Honor. I agree with Commonwealth that the declarant can be someone other than Ms. Kovac. However, in order for the excited utterance exception to apply, again, we can go to the death or the rule. Excited utterance is spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with first-hand knowledge at a time and under circumstances negating deliberation. Ms. Kovac cannot testify to whether these declarants had first-hand knowledge, whether it was at a time and under circumstances negating deliberation. She has no details about that. She would have, because she's not able to, the girls are not here, she's not able to testify to any of that. So the excited utterance exception would not apply.
So the court will reconsider its previous ruling, which I sustained the objection. I will now overrule the objection and allow Ms. Kovac to answer the Commonwealth's question, and the excited utterance rule does apply. Anything, what was the other point that we were going to consider? How are you going to lay the foundation to show the duration?
I would suggest, Your Honor, that before we bring the jury in, we have Ms. Kovac come back to the stand, and I will voir dire her briefly, just to establish the concern about the girls' knowledge of what they were reporting, whether it was spontaneous.
All right, we'll bring her back. Please share. Okay, if you please return to the witness stand. And you are still under oath. We're going to answer some questions outside the presence of the jury. You may ask you some questions. You may proceed, Mr. Jenkins.
When we left off, you were telling us about two girls running up to you. Yes. Could you please tell us what they said?
They said that JT had a gun in the bag.
Okay. So upon saying that JT had a gun in the back, could you describe their demeanor in saying that?
They came up to me, they were kind of, like nervous and worried and wanted help.
Okay, Judge, I think that lays the foundation for her to say what the girls told her under the excited utterance.
How long after well, first of all, how did they know that Justice had a gun in the bag? JT had a gun.
I don't know.
You don't know, okay. So as far as you know, as far as you know, someone could have told them that, correct?
I don't know.
Okay. Your Honor, just based on that, I believe that this is, again, that she has no knowledge of any firsthand, of how, if the girls had any firsthand knowledge, how they came to get that knowledge. And so then we run into hearsay, possibly hearsay within hearsay, if the girls heard it from someone else. She doesn't know. And so I believe, Your Honor, that this does not come in.
The standard in the site.
I'm sorry.
There's one other thing.
Okay, I'm sorry. Mr. Jenkins, yes, sir?
How do you know how long? Well, you don't know. You don't even know whether they saw the gun themselves, correct?
I don't know.
Okay, and you don't know. So there's no way for you to be able to know whether they are talking about a gun that was seen or by someone 5 hours ago, yesterday, correct?
I don't know. They reported and I acted.
That's my question. Your Honor, again, I don't believe it qualifies as a substitute hearsay rule.
The legal standard to be applied at this stage in determining whether an evidence exception applies is preponderance of the evidence. She has told us about the girls' demeanor, that they are agitated in that moment, and they say that JT has a gun. I think that to apply the exception, I think that is sufficient for the court to find that it was that they had firsthand knowledge. They were coming and asking for help in that moment, and that it was spontaneous in that they are physically having a reaction to something clearly that they have just seen. And so on the preponderance standard, I think we've met that burden, and she should be able to testify as to what the girls said.
The evidence is admissible. I will allow it in. I will overrule the objection, and can we call the jury back out?
Yes, Your Honor.
All right. Chair, if you kindly bring the jury back out, and just go back and just stay there. Go back. Yes, go back. I keep wanting to call you know that. Keep it there.
Please stand for the jurors. Looks like 14 years in.
Okay, and Mr. Jenkins, if you maybe back up a question or two, and you may proceed with your direct examination.
When we took the break, we had spoken about the question was, what made you warn Dr. Parker, right? And do you remember answering about what did? Let me ask you that. What made you warn?
Your Honor, I don't object. There's been no testimony. I believe you just said warn Dr. Parker. There's been no testimony of that nature.
I'm sorry. I apologize, Judge. Let me withdraw that. That's correct. I need to rephrase that question. That's correct about that. The question was, at some point later, do you tell Mrs. Werner to keep an eye on JT, did you?
Yes.
Okay. And what happened to make you give that warning to Miss Warner?
So the girls had reported to me, had come up to me as I was passing right after they came in to say that he had a gun in the bag. And I went into that room with the children and to him to try and see what he would say, to see if I could help and figure out what was going on, because him and I had a good relationship due to the modified schedule.
Okay. And without telling us what you or he said, did you at that stage get any information about a gun out of him?
I told him the rules of school, that we cannot have any guns in school, we cannot have any type of weapon in school, and I asked him if he had a gun in the bag.
Okay.
And then we went on with the lesson. He was acting very weird that day, out of character, balled up. I just sat quietly by him. His bag was by him. I said, give me that bag. He said, no one is going to touch that bag, which was very out of character. He also was talking about one of his friends at the time, Omar.
You're not, here's the objections to what you said, as far as what JT said.
So sustained game is kind of a narrative. Can you ask another question?
I can. Thank you, Judge. After you had observed these things with JT, did you talk to Dr. Parker?
Not at that moment.
Okay. What did you do as a result of what you observed?
So what I observed is it was time for them to do their assignment. And so JT asked for some school supplies. So I went up to Miss Warner and I said, he needs these school supplies. And I asked her when recess was, that I would be back when recess was, and I was going to check that bag.
I see. At that point, did you go and speak with Dr. Parker?
Yes, I did. At that point, I left the room right away and went to Dr. Parker's office, and I reported.
Hold on just a minute. At the time that you go to Dr. Parker's office, do you know what Ms. Werner's class was going to do?
They were going to head to recess.
Okay. And when you went to Dr. Parker's office, what did you tell Dr. Parker?
I'm going to object hearsay. I believe it's going to be a statement that's going to be offered for its truth.
Absolutely not. It's being offered for the fact that Dr. Parker was given the warning, not for whether the warning itself is true. It's not being offered to show that there is a gun. It's being offered to show that Dr. Parker was told there was a gun.
Mr. Rogers, anything further?
Again, the truth that there was, I guess what he's saying, there was notice, that's a very important fact issue in the trial. So it's offered for the truth of there was a warning.
Mr. James.
I am offering it for the truth that there was a warning. I mean, absolutely. But I'm not offering it to prove there was a gun. And also, Judge, it's a present sense impression. If the court were to find that it's hearsay, which I certainly would argue that it is not, it's also a present sense impression. It's an excited utterance for that matter. It's not offered to prove the fact that there was a gun. It's offered to prove that she was told there was a gun.
Let's pull up the hearsay rules.
Judge, if I could direct the court to a particular rule and section.
You may.
2801, subsection C, which reads, hearsay is a statement other than one made by the declarant while testifying at trial or hearing that is offered to prove the truth of the matter asserted. So this does not meet the definition of hearsay for two reasons. First, we are not offering it to prove the truth of the matter asserted. And second, the declarant is testifying at the trial. The declarant in this case is Ms. Kovac.
And response from defense.
Your Honor, I'll say this. Hearsay is a statement other than one made by the declarant while testifying at trial. Anything that was said outside of her statement on the stand is a statement other than while testifying at trial. So if she said something to Dr. Parker that's other than while testifying at trial, she can testify as to what she observed, but she cannot testify as to something that she said to somebody else.
So the court's ruling is that it is admissible. There is an exception to hearsay, not only under Rule 2:801, but under Rule, because it's hearsay within hearsay, is what the children told her that she then relays to somebody else. So under 2:805, hearsay within hearsay, it's not excluded if each part of the statement can come in under another exception. So the children's statement comes in under the excited utterance, so therefore it can come in as hearsay within hearsay. So I will overrule the objection, which means to the jury you can consider the response. Repeat your question, Mr. James.
Very simply, what did you say to Dr. Parker?
I went to Dr. Parker and I told her that two girls came to me and said that JT had a gun in the bag, and I told her that's what I told her, that I was warned that he had a gun in the bag. I told her what I did in the classroom, that I sat in the classroom with him, that he was acting very weird that day, out of character.
Okay, and so you relayed that information to her. Ultimately, was there a discussion about any additional action that would take place related to the bag?
I told her that when they go to recess, that I was going to go back and check the bag.
Okay, did Dr. Parker respond to that?
She had just acknowledged it with like a nod.
Okay. All right. So, what did you go check the bag?
At that point, I left. We were doing makeup state testing, so I went to my office, which is past Ms. Warner's room, and Ms. Warner had texted me at that point.
Okay, I'm gonna have you hold off right there.
Okay.
So just jump with me. Okay. Did you at some point go to the room?
Yes.
Okay. And
yes.
what did you do?
When they were at recess, I went back to the room. I checked his bag. Inside his bag was a puzzle, a math book, a little coin token, and then a calculator in the front pocket.
Okay. And what happened next?
After I checked the bag, I went back to Dr. Parker's office to let her know that I checked that bag. I told her the same items that were in the bag that I had seen.
Okay. And what did you do next?
After that, I went back and I went back outside to Abby and the class that was outside at recess.
Okay, I'm going to pause you right there. While you're outside at recess, without saying what anyone said, were there discussions among the teachers?
There was only her outside with her class at that time, and then I came outside at that time.
Did you and Abby talk?
Yes.
And had you and Ms. Werner, again, without saying what the content was, had you and Ms. Werner also communicated by text message?
Yes.
Okay. Now, as a result of those communications, again, it doesn't matter what was said, what did you do next?
So again, from the result of the text, I then went and checked the bag. I then went and reported a second time to Dr. Parker. Then I went outside to speak to Abby to see if he would come to me because of what she had said in the text. So he was behind the rock wall, did not come to me. And then I told her again.
But wait, you told who?
I told Abby.
Okay. Are there two conversations with Dr. Parker?
There were technically, there were 2 times I reported, and then 1 time I was in the office, and then Dr. Parker had told me that I could tell Abby an action to do if he misbehaved.
Okay. What prompted the first time you talked to Dr. Parker briefly?
The report of the gun.
From the girls?
Correct.
Okay. Briefly, what prompted the second time you talked to Dr. Parker?
The message that I received.
Understood. In the second conversation with Dr. Parker, what did you advise her of?
I advised her that the weapon in discussion was now in his jacket pocket.
And that was your belief?
That was my belief.
Okay. You mentioned that you had been at recess. At recess, did you have an opportunity to see JT?
I did not.
Okay. According to your understanding at the time, what was the protocol for teachers or faculty members to follow when they believed there was some sort of crisis developing?
According to the Rich Neck Handbook, we were to report to our administrators.
Your Honor, I'm going to object. Hearsay, talking about something in the handbook, it's being offered for true.
Response.
Your Honor, I just asked if she knew it, and it is knowledge that she had. She's not reading from anything. She doesn't have the handbook, so she's just saying that she has that knowledge of the policy.
I will allow Aaron to overrule.
Ms. Kovac, I want to take you to the moment on January 6th that a gunshot has happened. Do you recall that moment?
Yes.
Okay. And what was your first thought and what did you do?
My first thought was, he had that gun, he shot it, and I walked in that room. He hated me.
By in that room,
In Abby's room, room 11.
Okay.
He hated me.
Okay, hold on. Let me walk you through it. When you walk into the room, what do you see?
I walk into the room, Abby is to my left, and I see blood on her leg, so I know she was hit. To my right, the children are running out and screaming, going across to the hall to the open door. And he was standing right in front of me, arms crossed, legs spread, and cocky.
Okay. At that stage, do you see a gun anywhere?
I do. It's on the left, my left, slightly under the reading table.
Did you go to Justice?
I went
I'm
straight-
sorry, JT.
I went straight to him. He did not resist me. I took him by the wrist because I knew he shot left-handed. He's left-handed. I didn't want to ruin the gunpowder. Watched enough shows. I took him to the front of the room. I sat in Abby's chair. I put him in between my legs and my arms, and I picked up and I called 911.
Okay. And then after you did that, do police eventually arrive?
Eventually, it felt like eternity.
Yeah. So when they arrive, what position are you in? Are you still that same?
I'm still in that same position. So we were facing, like the phone is here, and we were facing as the police were coming in.
Okay. And as the police are coming in to the room, what is going on with JT? What is he doing?
You know, I'm going to object to relevance at this point. It's not relevant to these proceedings at this point. What happened after the gunshot, and whether Dr. Parker is guilty of anything. We've gone beyond what's relevant here in this presentation.
Your Honor, the statute contemplates the event. I'm sorry, there couldn't be anything more relevant. The event of the shooting and its immediate aftermath is precisely what Dr. Parker is charged with. The effect of her omission is what we're hearing right now. And so this is the very circumstance. It is the immediate shooting and its aftermath and its after effects for these children. And what she's describing is a present sense impression of something that is occurring as it's occurring.
So I will overrule the objection in terms of it's part of the incident and the immediate aftermath. Now the ongoing effects, there are going to be some limits on that. We can't talk about, I don't expect to talk about things more than 2 hours after this incident. Are you going past that?
Not with this witness, Judge, but with children and families that experienced ongoing effects from the neglect, but not with this witness.
And we'll take that up at a later point. But yes, you may continue with this witness. Objection overruled.
When police arrive, that's the part we're talking about. What is JT doing?
He is in my arms, and they asked me if I was okay, and if he was okay, and we were both okay. He became more agitated and cussing up the storm, and eventually, he was just spewing cuss words, stating, that he.
Your Honor, I'm going to again object to relevance here, and also the fact that this testimony is really more prejudicial than probative of any element of the offense.
I think the court has already ruled on that.
We didn't talk about prejudicial versus probative. You want to respond to that portion of the objection? That's a new objection.
Sure. All of the Commonwealth's evidence is prejudicial by definition. The question is whether it is probative. Probative is another word for relevant. Dr. Parker is charged with neglect of children that caused a shooting, and the testimony is about the shooting and its immediate after effects while there is still a gun on the floor, while police are arriving. So it is relevant, it is probative, highly probative, and therefore admissible.
So to the two-part objection from the defense, the court overrules it. The first part I previously ruled, so I note your continuing objection. As to the second part, prejudicial versus probative, it has to be, I think, substantially outweighed according to the admissibility standards in this case. Therefore, I rule it. I'm going to allow the testimony. You may consider it. Do you need him to repeat the question?
No.
Okay, you may finish your answer.
Okay, he was in my arms, he was getting agitated, he was cussing. I told him Mrs. Kovac does not like that language. He turned, gave me the finger, and then when I turned my head back, he punched me. My glasses went off, and I said that I was done, and I turned him over to the police.
Okay, and at that point, did you leave the room?
At that point, I did leave the room.
Okay, thank you. Now, Ms. Kovac, if you know, were police wearing body cameras while they were in there that day?
I knew that the one police officer said that he had the body cam on and got the whole transaction and my assault on the body cam.
If I were to show you a still picture from that, would you be able to recognize yourself and JT?
Yes.
Judge, I'm going to ask permission to show that to the witness at this time.
Okay.
And are you approaching the witness stand, or are you going to display it on the television?
First, I'm going to show it to defense counsel, then approach the witness stand until I've laid a foundation to show it.
Oh, yes, sir. Thank you.
May I approach the witness, Judge?
You may.
Just going to ask you to take a look at that. Can you see it clearly?
Yes.
I'm going to return and ask you some questions.
Okay.
Ms. Kovac, having had a chance to look at that still frame, does it depict you in the exact setting and circumstances that you've just testified to?
Yes.
Does it appear to you to be a fair and accurate representation as a still of a moment of that interaction you just described?
Yes.
All right. Judge, I am going to move to admit this into evidence as Commonwealth's one. It is a video that is approximately 2 minutes and 51 seconds. It depicts the things about which she has testified.
Your Honor, she was not showing video. She was showing effectively a picture that showed her sitting with this child in her arms. There's no way, based on that, just seeing a picture, that she can properly authenticate that video. So what we need to do is exclude the jury, let her see the video, and then she can testify that what that video portrays accurately describes what occurred on the day. But right now, just based on a picture that doesn't authenticate, well, effectively it's a picture that doesn't authenticate the video.
Your Honor, additionally, Your Honor, I believe the video is cumulative. And again, it's just shown to prejudice Dr. Parker. It's the prejudicial value substantially outweighs any probative value that a video of the interaction would have.
Judge, I'll address the first one. It sounds like it's an authentication objection. I was hoping we would avoid sending the jury out, but counsel is right. If we, to authenticate the video, I need to show her the video and let her authenticate it. So.
Okay, yes, because you said it's still photographed.
That's right.
Now we're talking about 2 minutes and 51 seconds. But I mean, if you could just play it without the volume, if that's adequate, I don't know, then she can just watch it right there in the witness stand before we publish it.
Yes, without the audio for her purposes.
Yes, if that's sufficient for authentication. And again, I don't know, I haven't seen it.
That's sufficient for me.
Okay.
I don't know.
And then what was the second objection, prejudicial versus probative?
And cumulative, Your Honor.
And say, I didn't hear you.
Cumulative.
Cumulative. Okay. So I overrule on both of those. And Mr. Jenkins, are you able to play it?
Yes, Your Honor.
And so again, he's going to approach and play it for you silently. Yes, ma'am.
We're still having trouble hearing.
Still having trouble hearing them. Okay. Mr. Rogers, I don't have a microphone. I don't know what we can do if they still can't hear you.
Yes, ma'am.
Nobody ever has trouble hearing me.
And we're just going to sit quietly while this. I'll show you the witness. And while she's watching that, should she be able to state that it's a fair and accurate representation? Are you going to put it on the big TV?
That is the plan.
Is the podium turned on? It takes about 2 minutes to warm up.
It is on. I tested it earlier.
I was going to say, get it started if it's not started.
It looks like someone has changed the TV since I tested it earlier, though.
Okay, so
It's,
let's find the right source. Input.
I get it on.
Okay, great.
That's it. We're good.
Your Honor, could I just add to our objection to the video? Your Honor, our client is charged with 8 counts of abuse and neglect of children. What happened to Ms. Warner is tragic. And the behavior that Ms. Kovac had to endure on that morning after this shooting event, that was tragic also. But I believe she testified that the shot was fired. She turned around and went into the room, and as she was going into the room, the children were leaving the room.
what's your objection?
There were no children present. They weren't at the moment that she's about to testify, there were no children that were subject to abuse and neglect.
Okay, this sounds like a motion to strike, so I'll hear that then. Okay.
Okay, may I approach, Your Honor?
You may.
Ms. Kovac, you've just watched a video. I'm sorry, is that yes?
Yes, sorry.
Thank you. Does that video fairly and accurately show what happened in those moments that you were just describing in your testimony?
Yes, it does.
Judge, I do move the video into evidence as Commonwealth 1.
Defense, you've already objected, so there's some noted, no parole, and you may play the video. This will be marked, again, you said Commonwealth 1?
Commonwealth 1, Your Honor. And for the purposes of the media coverage, this video, we have muted the name of JT and Judge, I'll provide what the court has ruled to be Commonwealth 1. It is a USB drive inside a envelope labeled Kovac JT in classroom. May I approach?
You may, and so marked and so received.
Thank you, Ms. Kovac. I don't have any more questions for you, but please answer any questions from defense counsel.
Your Honor, before I start my cross-examination, can we take a brief recess?
Okay.
Or can I just step out?
Yes, you can step out. We'll just be quiet. Yes, sir. defense ready to proceed with cross-examination?
Yes, ma'am.
All right, please do.
Okay. Name is Amy Kovac,
Yes,
and I believe you testified that you have been a reading specialist for 16 years?
13.
13 years? And how long have you actually been a teacher?
33 years.
A lot of experience in the school system.
Correct.
Is that entire time with Newport News City Schools?
No, the first 10 years were in King and Queen County. I've been with Newport News for 23 years.
Okay. All right. And would you agree that you had actually spent a lot of time with JT prior to this incident?
On the modified schedule, yes, so from October through January.
So you were used to his ups and downs, is that correct?
Correct.
Okay. He had good days?
Yes, with me.
Okay. And obviously, even prior to this day, he had some bad days?
Correct.
Would you agree that the Wednesday prior, just immediately prior, he had a bad day?
Correct.
Were you there to see and observe his behavior on Wednesday?
In the classroom,
After the classroom incident?
I was in the office when he was brought up.
Okay. All right. And are you aware who brought him up?
Mr. Rawls.
Okay. All right. Do you know why he was brought up?
He didn't tell me then. I called for the buses at that point.
Okay. But you knew there was an incident in the classroom, that he was brought out of the classroom? Is that correct?
I knew that he was in an incident and was carried to the office.
Okay. All right. Okay, good. All right. So would you agree that it's the teacher's responsibility, primary responsibility, to make sure that the students in their classrooms are safe and protected from any harm?
It is the teacher's responsibility to teach the children, to have a schedule for the children, and to handle disruptive behavior, not excessive behavior, is my understanding.
Okay. So you would agree that if there's a disruptive student in the classroom, the teacher has the authority to remove that child from the classroom?
She can usually call for help. That's what I would do.
So you're saying no, a teacher cannot remove a student from the classroom for disruptive behavior?
I mean, to another classroom. It just depends on what the classroom plan is and the school's rules are.
So yes or no?
I don't know.
You don't know? Okay. All right. Have you ever removed a student from a classroom for disruptive behavior?
In my classroom as a general ed teacher?
Sure.
Or as a reading specialist?
A general ed teacher?
Yes, I've moved them to another classroom.
Okay. All right. You would also agree that a teacher has the ability, if a student is disruptive, to take them down to the administrative office?
If there's someone to watch their class if needed.
All right. So obviously, you don't want to assign any blame or responsibility for the classroom teacher for JT's behavior on that day. Is that correct?
Objection. This calls for speculation. Is an opinion about whether she wants to assign something to someone.
I'll let the court rule on it.
It's cross-examination. He's allowed to forward back the witnesses.
It's not my place. I mean, I don't know it. I can't think for somebody else. I can only think for myself.
Okay. All right. So let's start when you first became aware that there may be a problem with JT. Okay. I believe it was the incident with the two young girls. Is that correct?
For that day?
For that day.
No, that was not the first time.
Okay. What was the first time that you had any kind of indication that JT was having a bad day?
When Ms. Warner came in to report that he had been acting up in the lunchroom, and she was reporting to Ms. Parker. Myself and Ms. Harris were in there because it was testing, and we had just returned our tickets. Dr. Parker did not look up at her, did not acknowledge her.
Okay. You did not observe this behavior yourself. This was just something.
I did observe that behavior.
What observed?
Not Justin's behavior.
That's what I'm talking about. I'm talking about JT's.
But Dr. Parker and Adam's behavior, I did observe.
Okay. All right. And then you had the encounter with the two young girls. Is that correct?
Correct.
All right. And so it sounds like, based on your testimony during direct examination, that that you believe the girl's assertion that JT had a gun. Is that correct?
Correct.
Okay. So obviously, if JT had a gun, then he presented a danger to the students in his classroom. Is that correct?
Correct. Correct.
Okay. All right. So you went to investigate that. Is that correct?
I walked into that classroom to speak with him.
With the belief that he had a gun. Is that correct?
With the belief that there was a possible weapon.
Okay. All right. And so, and you observed that he was acting off. Is that correct?
Correct.
Okay. You, along with his teacher, had the authority to remove him from the classroom. Isn't that correct?
We had already told her that
I'm talking about your authority. You had the authority, along with Ms. Warner.
I don't know.
Okay. All right. But even with you indicating that you believe that he had a gun, you spent some time with him, and then you left him in the classroom, even though you believe that he had possessed a gun. Is that correct?
I left the classroom to report as required by my school.
If a student had a gun, don't you believe it's required that you separate that student from the other students so he doesn't present a danger of harm to those students?
Objection's been asked and answered 3 times now.
Response?
Your Honor, I'm just trying to make sure that she clearly indicates what her responsibilities are regarding the safety of the children.
Ask it one last time. For the safety of the children, I did not remove him at that point.
All right. So then you said that you actually spent some time on the playground when JT was with his classmates. Is that correct?
I went out to the playground, did not spend time. I was testing and had to get back.
But you believe that he had a gun on the playground. Isn't that correct?
I'm not sure what kind of gun, I'm not sure what kind of weapon. I had not seen it myself. I only heard the reports, and I reported as required.
But you said you believed it was a gun. Is that correct?
Because the girls reported.
And you believed them?
Any report of a weapon in a school, I'm reporting, and I did.
All right.
More than once.
Is there a possibility that you thought it was a toy gun versus a real gun?
I mean, my personal thoughts are my personal thoughts, so.
Did you express to anybody that you thought it was probably a toy and not a real gun?
Yes, after the incident, the police have it on police cam.
Right.
That was my thoughts while I was in shock.
Okay. So you believe there was a real gun, and then you left the other
I
student?
did not know if it was a real gun or not at that point when I was in the room with him.
So you didn't believe that he had a gun?
Objection, Your Honor. He is misstating her testimony over and over within his questions.
Response, Mr. Rogers.
Your Honor, she's trying to have it both ways. She indicated on direct examination that she believed he had a gun. Now that I am assigning her responsibility to her, she's trying to say that, well, I don't know. What I believed at the time, she's acknowledged that she did tell somebody that there was a toy gun. So I'm just trying to narrow down whether or not she believed it was a gun or not.
Okay, and your objection to fleshing that out is what, Mr. Jenkins?
It's that she has already said the answer. She has already said that it could have been any kind of gun she didn't know. And he keeps restating her testimony differently than that. He keeps saying, you believed it was a gun. And she keeps saying, I didn't know if it was a gun.
Well, I think he switched to her stating something different purportedly on the body cam that now it's a toy gun. And again, strong cross-examination, vigorous cross-examination is fundamental of our justice system. So overruled, you may proceed, Mr. Rogers.
Your Honor, may I address one other issue?
Yes.
I'm hearing in the courtroom gallery commentary coming over my right shoulder I just think the gallery needs to be informed that they're not.
Okay, and I can do that. And I heard something, I just couldn't tell the direction. I need absolute silence from participants in the courtroom. We cannot comment, we cannot bolster, we cannot suggest our opinions in any way, and please govern yourselves accordingly. This is an open public proceeding, but if people are disruptive, they will be asked to leave. Comments are considered disruptive, and I can't close this courtroom. I'll ask everyone to govern themselves accordingly, and I think the sheriff will start keeping an eye out for that. I know he was. So sheriff, if anybody making noise, please escort them out. Thank you. All right, please proceed, Mr. Rogers.
Thank you, Your Honor. So it sounds like now you're saying that you weren't sure if he possessed a firearm. Is that correct?
What I'm saying is, the girls reported that there was a gun.
And you believe them?
And I...
Yeah, let her finish her response, Mr. Rogers.
I acted on the report. Children were 6 years old, first grade. I acted on the report. I went to see what was going on with him. I did not look in the bag. I did not touch the bag. I was in the room. When I left the room, I went and reported to my administrator.
Did you leave that?
Are you finished your response?
Yeah.
Okay, next question.
Did you leave that room believing that there was a gun?
I left that room believing that there was something in that bag.
Something that potentially presented a threat of harm to those children.
And this is ask and answer, Mr. Rogers.
All right.
Next question.
All right. All right. And then let's talk about the playground. Same thing, right? You knew that JT was out on the playground. Is that correct?
Correct.
All right. You said that you didn't visually see him yourself, but you knew he was present. Is that correct?
Correct.
Okay. He was out there with his classmates. Is that correct?
Correct.
All right. Miss Swarner, his teacher, was out there. Isn't that correct?
Correct.
Okay. There was nothing that prevented you or Miss Swarner on that playground to separate JT from the rest of his classmates. Isn't that correct?
No.
All right. So you said that you searched his backpack. Is that correct?
Correct.
Okay. After you searched his backpack, did that dispel any fears that you may have had that he possessed a firearm?
No.
Okay. So you continued to think that he potentially had a firearm. Is that correct?
Something. He had some kind of weapon.
When you say some kind of weapon, are we talking?
We're talking gun because that's what the girls reported. I did not know what was in that bag.
So are you holding out the possibility that it's a toy gun?
I'm not sure what it was.
Yes or no?
It could have been, yes.
All right. So if it was a toy gun,
We still report and we still investigate.
I got you, but it's not a toy gun is not a threat of harm to the children. Isn't that correct?
If there is a report, it is required by the state that you report.
Do you understand my question?
I do understand your question.
Okay, does
Okay,
it?
hold on. For everybody, we're going to lower the temperature in the room. So the objection would be non-responsive because she did not answer your question. She answered a different question. Can you repeat your last question, Mr. Rogers?
Do you believe that a toy gun presents a threat of harm to those students?
He couldn't. Yes. Yes, it could.
Okay, explain. How in the world a toy gun could present
A BB gun, a water gun.
I said,
any kind.
my question was...
She answered the question. What's the next question?
Okay. So you consider a BB gun as a toy gun, is that correct?
It's a gun. You report for any type of weapon. I reported it.
All right. Just going back a little bit, when the girls made this report to you, did you take them down to the office to speak to administration?
I did not.
All right. Do you think it may have been important to take them down to the office too?
I did the actions that I did in that day, and I cannot look in retrospect.
Okay. Who gave you the authority to check the backpack?
According to the crisis plan, we are allowed to. We just cannot check your body without permission from the administrator.
Okay. So did Dr. Parker give you the authority to check the book bag?
She acknowledged when she heard that I was going to do it. She could have gotten up and done it herself if she wanted to.
Okay, so let's talk about, you said you're a part of the crisis, what is it, crisis management team?
I'm not part of the crisis management plan. I said in the crisis plan that the district holds.
So you're not a part of the crisis management team or any kind of crisis team at the school?
No, I am the reading specialist, and if the principal and administration gives me another duty, then I do that.
Okay, but nobody told you, Dr. Parker or otherwise, that you did not have the authority to remove JT from the classroom. Is that correct?
No.
When the police arrived and you were holding JT, were there any students in the classroom?
No.
Okay. At what point did the students leave the classroom?
When I was walking in, they were coming out.
Okay. So by the time that you took a hold of JT and sat down with him, there were no students in the classroom. Can I have a moment?
Okay.
After the firing of the firearm by JT, one of the steps that you took was to call the police. Is that correct?
Once I had a hold of him, yes.
Okay. So that phone was readily available to contact the police?
It was her school office. It was her school phone.
Okay. Were there also walkie-talkies that could be used to communicate with administration?
There is, but I did not have my phone or my walkie because testing had just finished. And state testing, we cannot have that. So I had none of those.
But you did have the classroom phone that you could have easily called down to the administrative office. Isn't that correct?
After the shooting I did call, it was busy the whole time.
All right. So before then, you took no steps to call the police. Is that correct?
Correct.
And okay, so, but you did communicate with administration face-to-face, is that correct?
Correct.
All right.
Several times.
All right. After the incident, did you have communications with Dr. Parker?
Yes.
Okay. You understood that she was very upset about the things that occurred on that day. Is that correct?
Well, first of all, I was in shock that day. I did speak to her. We were considered work friends, so I checked in on her. I asked her if she called her husband. I asked her if I could use her phone to call my husband.
Okay. And you indicated to her that the events that had occurred on that day were unfortunate.
Objection, hearsay.
Okay, so go ahead to finish your entire question, and then I'll move on to that.
You indicated to her by some communications, by text or in person, that you believe that the events that occurred on that day were not foreseeable. Is that correct?
Okay, and hold on, that's where I'm going to go. Okay, and your objection is what? If you fleshed out a little bit more, Mr. Chambers.
So he's asking about an out-of-court statement offered for the truth of the matter. He's asking about an out-of-court statement that she said to Dr. Parker. So, and it's your response.
I'll submit it to the court.
So suspend. All right. So do not answer. Next question, if any.
Okay. And so, just briefly going back to the backpack. So, you searched it, didn't find anything that you believe presented a danger. Is that correct?
Not at the time, correct. Yep.
Okay. Did you observe at all JT on the playground? Did you observe what he was wearing? You know, anything that he may have had in his pockets?
No.
All right. Your Honor, I'm going to check with my co-counsel one more time, and then I think I'm done.
Yes, sir.
I'm sorry, I just want to return to the backpack again. When you asked JT to search, to let you look into his backpack, and he said no, was that alarming to you?
His actions were alarming to me.
Okay.
Words that come out of his mouth, it's hot and cold every day.
So you're saying you didn't take that seriously?
I took it seriously because I reported 3 times to the administrator.
Okay, but not seriously enough to say, let's take JT to the office, or let's get his classmates out of this classroom, because I think that...
Objection asked and answered.
Talking about the backpack now, Your Honor.
Oh, well, go ahead.
All right. So not enough to take JT's classmates out of that room for any potential harm.
I did not know what his next actions would have been at that moment, and to keep the children safe if there was something, because a weapon had been reported and no administrator did actions.
Okay, so you could have taken some steps to keep them safe.
I did, as what I could at that time.
Okay, so that's all you could have done is reported to the administration. You couldn't have taken JT out of the classroom. You couldn't have taken the students out of the classroom.
In retrospect, maybe, but I did what I did.
All right. That's all the questions I have.
Can you redirect?
No, Your Honor. Thank you, Ms. Clement.
And this witness status in terms of being sequestered, excused?
I would request the same with all of our witnesses. I'm asking that she remain sequestered but be able to leave. Certainly she is subject to recall by either party.
I agree.
Okay, so Ms. Kovac, you are welcome to leave the building, but you are still a sequestered witness, meaning you cannot discuss this case until the trial is over. And it's my understanding that attorneys have your number, so if they need to call you back for subsequent testimony, please be available. All right, thank you, ma'am.
Okay, thank you.
Down. And again, you're welcome to leave or stay, but you can't stay long. Okay, we do another witness. Got about 20 minutes before we break for lunch. Can we start with another witness?
Judge, I have one witness that we could do, I think, very quickly.
Okay, who would you like to call, please?
Deputy Blythe.
Blythe?
Blythe, B-L-Y-T-H-E.
Okay, thank you. One moment. Sheriff, Deputy Blythe, please. Thank you. Good morning, sir. Please stand in front of the clerk and get sworn in.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
I do.
All right, please take the witness stand. Watch your step, and you may adjust the chair and microphone. Counsel.
Good afternoon, sir. Please tell us your name.
My name is Thomas Blythe. I'm a retired deputy from the Newport News Sheriff's Office.
And were you working as a deputy on January 6, 2023?
I was.
And on that day, did you have occasion to go to Rich Neck Elementary School in Newport News?
I did. I responded to a radio call of an active shooter at the school.
All right. And did you go to the school?
Yes.
And what did you do when you arrived?
Pulled up in front of the school. Deputy Briggs about a half second behind me. We went to the door, tried to get in, but the intercom wouldn't work at the door. There was nobody to meet us. Everything was locked up. We were joined by a couple of Newport News police officers. All four of us pounding on the windows, yelling, trying to get somebody to open the door for us.
Okay. Did you observe an intercom system of sorts on the door on the outside?
There was an intercom on the door. It didn't appear to be working, or at least nobody was answering it.
Okay. Eventually, does someone let you in the door?
After about a minute, it was either, I think it was a janitorial staff.
Okay.
Opened the door for us.
And roughly how long were you out there prior to a janitorial staff opening the door?
I think by the body camera it was about a minute, maybe a minute and a half.
Okay.
Felt like in turn.
Yeah. Were you armed and willing to go in and confront?
We were in full uniform, armed, responding to what we thought was an active shooter.
All right, thank you. I don't have any further questions for you. Please answer any from defense counsel.
No questions, Your Honor.
Thank you. Does Detective Blythe need to remain?
No, I actually, if there's no objection, I think he could be released. Yes, so we would like to release him from recall.
Okay, to confirm defense position.
No objection to him being released, Your Honor.
Okay, so thank you, Detective, for your testimony. And being released means you are welcome to stay in the courtroom or you may leave. Thank you, sir.
Thank you, Your Honor.
All right, next witness.
Judge, my remaining witnesses may take a bit more time than that one. Do you want to go?
I would like to start. Yes, please.
Now I'll call Brianna Foster, please.
Brianna Foster. Ms. Foster, please. Good afternoon. Please stand in front of me to be sworn in.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Okay, and you may adjust my phone to any questions the attorneys may have.
Good afternoon.
Good afternoon.
Would you please tell us your name?
Brianna Foster.
And Ms. Foster, back in January of 2023, how were you employed? Okay, I'm going to ask you to speak up a little bit. It can be kind of hard to hear. Did you say that you were could you repeat what you said?
And I was employed with Newport News Public Schools as a principal.
Okay, and what school were you a principal at?
Richmond Government
Okay. Ms. Foster, if you know, had your school at Rich Neck Elementary adopted a crisis and emergency management plan?
Yes.
And if I were to show you the plan, would you recognize it?
Yes.
Okay. Judge, may I approach?
You may.
Yes, yes. May I approach?
You may.
Just take a look at that document there, and I'll ask you some questions about it. You don't have to say anything about it at this point.
John, getting ahead of this, if they're going to try to talk anything out of that document, it's going to be offered for the truth of the matter asserted, and I'm going to be objecting to that document as hearsay.
All right. Understood that that's coming, and when it becomes right, I'll be ready to hear the objection.
Ms. Foster, just let me know when you've had enough time to look at that document.
Do you need me to look at it in full, or just?
My question is going to be, is that a fair and accurate copy of the Rich Neck Crisis Management Plan as you remember it?
I cannot answer that in full, but I remember that it's a very accurate representation.
Understood. I'll take it back. At the time that you were working on January 6th of 2023, were you aware of the crisis management plan?
Yes, I do recall that we have one.
Okay. And what was the purpose of having a crisis management plan at all?
We're just required to, every school is required to have one.
Okay. Was it your intention that you would follow the crisis management plan in a crisis?
Yes.
Okay. I want to take your attention then to January 6, 2023. On that day, was there a crisis incident that occurred at the school?
Yes.
Okay. And what was that in brief?
Later that afternoon, I found out that there was a student, it was reported that a student had a weapon.
Okay. At any point, was there a critical incident that required police to show up?
Would you mind clarifying what you mean, how?
Did something huge happen on January 6th of 2023? That's the whole reason we're
Yes.
here? Okay. And what was that?
That a student shot his teacher.
Yes. So I want to ask you, prior to that moment, the moment of the shooting,
Yes.
had anyone...
Your Honor, I'm sorry. I'm going to object to her response to the question unless she actually observed the incident. I don't think that she was present when that occurred, so she can testify to what she observed, but she has made a conclusion that I don't think she can really testify to.
Response.
Judge, it's the incident for which we are here. She's the principal of the school. She knows what happened at the school that day. I'm just trying to orient her in time so that I can ask a question.
So I'll overrule it as receiving that posture as to why are we here in court today, the incident that brings you in court today. Not that she observed it or anything
Yes.
further than that without further questions in the testimony.
Thank you,
So what's
Judge.
your next question?
Prior to that event occurring at your school, did anyone tell you that JT or anyone that there was a weapon on campus?
No.
Any hint from anyone that there was a weapon on your campus prior to that?
No.
Roughly how many students attended Rich Neck at that time? And I don't mean on that day, but just the total number of students that would have been in the school. And you can give us an estimate.
I truly do not recall, but if I had to give you a number, maybe 500.
Okay. I want to talk to you about a student named JT. Are you familiar with who I'm talking about?
Yes.
Okay. We're not using any student names at all, so any students that you mention, please don't use their name. Had you personally, prior to the incident on January 6th, so earlier that year, had you personally had any issues with JT's behavior that you saw?
Yes.
That's irrelevant, Your Honor.
Okay, what's the judge? I didn't hear you, Mr. Chairman.
Relevant, Your Honor.
Relevant. Okay, response?
If she handled a discipline issue with JT that the defendant knows about, then it's relevant, as all of those are.
We've allowed those in previously, so I'll allow this in to be consistent. So you may proceed. You can answer the question. Do you need him to repeat the question? Yes, please.
So the question was, in the time before, the days before the shooting, had you personally been aware or observed behavior of JT that was a discipline issue?
Yes.
And could you just describe that?
To my memory, earlier that week, there was a situation that took place between him and his first grade teacher involving her cell phone.
Okay, and did that situation come to you?
Yes.
And who appeared to you to inform you?
I think it was 2 people that came to me. I don't remember if it was his teacher.
Okay.
I'm sitting here trying to think back exactly how I knew about it, but I remember calling his mother that evening.
Okay. So as a result of that incident, you did contact his mother?
Yes.
Okay. Any other specific instances, discipline-wise, of JT that year? That you remember? If you don't remember, that's fine to say that.
Not in detail, but there were other incidences that took place.
Okay. If you know, did the school attempt to do anything to try to moderate that behavior?
Yes.
And what was it that the school did to attempt to control the behavior?
I don't remember the name of the process that was in place. However, they met, it was a scheduled number of, let's say, weeks or throughout the month where they would meet with the teacher, assistant principal, parent, and Ms. Kovac to go over his progress, academics, behaviors, and come up with a plan, essentially progress monitoring how he was doing it in school.
Okay. And I just have one last question for you. Is it true that you were working at the school hand in hand with Dr. Ebony Parker?
Yes.
Okay. And is Dr. Parker in the courtroom right now?
Yes.
Okay. Could you please just describe what she's wearing and identify her for the judge or point her out?
Yes. She has brown and black hair. If I'm not mistaken, she has some blue.
And just may the court recognize she's identified the defendant?
So noted.
Thank you. I have no further questions for you. Please answer any questions of the defense counsel.
Thank you.
Good afternoon. How are you? Just a few questions. There was a crisis management plan in place, is that correct?
To my knowledge, yes.
Okay.
Okay.
All right, I'm sorry. So there was a crisis management plan in place, is that correct?
To my knowledge, yes.
Okay. And if there were any type of crisis at the school, had you instructed any of the teachers or staff not to come to you with that crisis?
No.
Okay. Was it the policy of your school for staff members to bring problems to Dr. Parker, and if whatever she said goes, or were you ultimately responsible for the safety of the students at your school?
To my knowledge, it's a joint. In my previous positions, it's hard to say. Like, ultimately, I am as a principal, yes.
Okay. So, would you expect your staff members, if they weren't satisfied with whatever was brought to the assistant principal, that they should bring whatever that crisis or problem to you?
Yes.
Okay. Did that occur on January 6th of 2023?
No.
Could any teacher who had a disruptive student in their class, could they have brought that student to the administrative office?
Yes.
Okay. Would you expect them to bring that student to the administrative office?
Yes.
If any teacher or staff member had the belief that there was a firearm possessed by a student, would you agree that that student should be separated from the rest of his classmates?
Yes.
Okay. Would you also agree that law enforcement should be immediately notified?
Yes.
Before the shooting, as far as you know, did any of those steps take place?
To my knowledge, no.
All right. Can I have a moment, Your Honor?
Yes, sir.
Your Honor, that's all the questions I have.
Thank you. Any three correct?
Briefly, Judge.
So on January 6th, during that day, what were you doing and where were you in the school?
Do you want a timeline of the whole thing?
As much as you remember, it's fair enough. If you don't remember, you can say you don't remember, but just as much as you remember, where were you and what were you doing that day?
That day we had some interviews in the morning. I subbed for a gave teacher a break so she could handle lunch for herself, a personal lunchtime.
Now, when you were doing the interviews, where would you have been in the school?
The main office in my
In your office, okay. And then the second thing you said you did was what again?
relieving teacher so she could have a lunch break.
So that would have been in a classroom?
Yes.
Okay. Then what?
Then I remember we had a family and military life meeting with the new partnership that we were forming
Okay, where did that occur?
in our conference room.
Okay.
And then after that, during that meeting, I remember emailing our lead custodian to ask if I think I walked through or emailed our lead custodian, maybe Dr. Parker, asking about space, because they wanted to know about space, and I couldn't remember off the top of my head where we could put them. And then after that meeting was over, Dr. Parker and our lead custodian came to my office, in addition to 2 students who were waiting to speak with me came to my office.
Okay. And while you're in your office, what's the first signal you get that something is wrong?
I think the words I heard were, he has a gun, or she's been shot.
Okay.
And then
What did you do?
from there, I slammed my door, and I took the two students who were in my office and everyone else, and I shoved them into the bathroom and tried to barricade them in. I called my direct supervisor and 911, and we were telling everyone in the bathroom that I'm going out. And I remember someone saying, "You can't." I have to. And then when I went out, Miss Zorner was on the ground, and there were staff. And I remember saying, like, "Please put this school in lockdown." And Miss O looked up. I looked up, and Miss O said she had already put the school in lockdown.
All right. Thank you. I don't have anything further for you.
Your Honor, I don't have any follow-up.
Thank you. And the status of this witness?
I would ask that she be constructively sequestered and subject to recall.
No objection to that, Your Honor.
Okay. So, Ms. Foster, what that means is they're done with their testimony for now. They may recall you to come back to the witness stand, but you don't have to physically stay in the building.
Okay.
So you may leave the building. Just make sure that the contact information is good. So if they need to recall you as a witness, they can. You cannot stay in the courtroom, and you cannot discuss the case until it's over.
And does that mean for the remainder of the trial?
Yes, for the remainder of this criminal trial, until this trial is concluded, you cannot discuss your testimony. You are a sequestered witness, but we are not going to require you to remain in the witness room. So you can go about your day and be available if we need to call you back. And they'll let you know when the trial is ended in case, so with that, when your sequestration ends.
Okay.
All right? Thank you very much. And at this time, can we break for lunch?
Yes, Your Honor.
Yes, ma'am.
All right. And so it is 1:05.
Judge, can we let the witness?
Yeah, well, yeah, come on down while I'm talking. So we'll break for lunch. Is there any motions that we need to take up? I'm trying to time when the jury should come back.
Nothing comes.
None from the defense.
So let's come back at 2:15, which means I need all the jurors to report at the room downstairs or back here by 2:10. We need all the jurors to come back at 2:10. I'm giving you an hour, and we will resume at 2:15 p.m. Again, jurors, do not discuss the case, do not research the case, and you're welcome to leave the building or there's food back there in the jury room if you want to stay in the building. Okay, we are in recess. Thank you.
Please stand for the jurors. If you leave it, someone will come up here. Thank you. Court stands in recess.
And I just forgot all of it. This is prior to finding my dad. And, I didn't want to be like, hey, there was I went to go see if there was a gun down there, and it's not there anymore. But, back when I found it, Melody was gone. My dad was at work, and I just forgot all about it. But for some reason that day when I went to go check to see if the shotgun was there, it reminded me that gun was in that drawer. And just something told me to go just check to see if it was still there.
Did you, afterwards on the 5th, when law enforcement came, did you talk to them?
Yes.
Did you tell them about this gun?
Yes.
Did you tell them about the blood?
Yes.
Did you tell them about other things you found unusual?
Yes. Or her behavior and stuff like that, yes.
And then you talked to law enforcement on July 5th, I believe, at the scene. Is that with
Yes.
Detective Kuykendall in the vehicle?
Yes, I sat in the passenger seat, and I honestly don't remember who all was in the vehicle, but there was somebody in the driver's seat, and then I remember there was either one or two people in the back seat.
And then Detective Hayes is behind me. At some point the next day, I think you went and talked to him again?
I want to say it was him that night, because...
Yeah, that night into the next day, down at the Freedom Precinct.
Yes, I don't really remember talking to Detective Hayes right there on the property. My memory that I think the first time I remember talking to him was at the Free Home Fire and Police Precinct.
So one time on the scene, and then talking to the detective at the precinct.
Yes, there was a lot of police officers and detectives and everybody out there, so I can't say exactly who I talked to at all from my knowledge, but I talked to a lot of different police officers.
Just this time on 10 to evidence state's exhibit. So it's S-Ferris 7, S-Ferris 8, and S-Ferris 9. On this one here, you see there's some text message between you and your dad on the cell phones?
Yes, I do.
Let's start at 112. So 6/6/2018, 9/18/36. You see that?
Yes, sir.
All right, it's from you to your dad, and then we're going to go upwards.
Oh,
all right, so let's start.
It looks like it's from my dad to me.
Yeah, to you from your dad, and what is that message?
DirecTV guys coming. Come here and let me show you the ISSR.
Then from you to your dad, the next one up.
Did they give you a time frame on when they will be here?
Going up to the next one. Okay. Looks like to you from your dad.
Yes, he responded before 12.
And then the last one there.
He called and some mix up. He will be there around 2.
And he thought it was AT&T. Could it have been DirecTV?
I believe AT&T and DirecTV are the
But this
same
is what you're
company.
talking about.
Yeah, this is what I'm talking about. It was to do with the satellite, so DirecTV is satellite.
This is S-Ferris 7. This is something we've pulled in the case. Can you see the date time here at the top? Can you just tell us what that is?
2018, June 5th, time is 12:48.
And then the message contents, just read that for us if you would. He would reply yes.
Reply yes to confirm your DirecTV appointment at 6/6, 8 a.m. to 12 p.m. Reply no to reschedule. To stop receiving this message, reply stop.
Then S-Ferris 8, this is a June 6, 2018 text from them. And the message contents, what does that say? You can just
Hello, we recently completed the direct TV visit. If you're experiencing service issues, please reply or call 678-971-2219 to guarantee tech within 24 hours.
Were you running around repeatedly saying there's lots of blood down there, there's lots of blood down there, or anything like that?
I never once said that.
I want to juxtapose two points on June 5th and June 6th. So one is when you're at the scene and you're talking to law enforcement, and then June 5th going into June 6th at the Freeholm Precinct when you talk to law enforcement.
You mean July?
Yes, excuse me, I'm sorry. July 5th and July 6th. The two positions I want to talk about is when you're at the scene and then you're down at the precinct, at what point did you learn that there was actually a bullet was found in your father's rib?
So we were there very, very late at night. I know it was probably close to 11, midnight or so. And they kept us in a kind of a conference room. And they brought us one by one back into another room individually. I don't remember who they brought back first and all, but by the time they brought me back, I believe it was Detective Hayes that was there with me. I don't really remember the details of what all was discussed at first, and then I was informed that they discovered a bullet lodged in the rib bone.
Do you remember Detective Hayes saying, "I've got something I got to tell you"? You remember how he broached that or told you about it?
I don't remember his exact words on how he did that because, you know, once I was told that that was happening, that happened, my mind just went into kind of shock, I'll say.
At that point, did you suspect your mom?
Definitely.
Was she there with you at the precinct?
She was there in the room that we were all kept in at.
Who else was there?
Amanda was there. Possibly Chad, Bruce. I don't remember if Chris and Emily were there.
After you were told that, did you go out and talk to others about what you were told?
That night?
Did the other family members, were they told about the bullet?
I don't remember discussing that with them, you know, after I came back out of the room.
What, did you ask your mom anything when you left?
I really don't remember if I did or not.
Afterwards, after July 6th, you couldn't go back to the property?
No, so, you know, they informed us for us to go up to that precinct, and we were all, you know, able to drive up there. We didn't have to ride in any squad cars or anything like that, but they did inform us that we were not allowed to go back to the property. So, from what I remember, Melody went and stayed with Amanda, and, you know, once we were fully released for the night, I left and went back up to the lake house because Ted was there and some other friends. So I knew I had somewhere to go to sleep that night.
Afterwards, was there a splitting of the family afterwards? Like some went one way and the others went the other way.
Oh yeah, I mean, once we found out that, you know, there was a bullet found in the rib bone, that, you know, obviously he's been shot and then burned, and we all put the pieces together because my dad had no enemies. I never once met anybody in my entire life that hated my dad. So we knew somebody, you know, wouldn't have come there. The house wasn't wrecked. I mean, there was nothing everything was adding up to us that it wasn't a robbery and it wasn't anything like that. And, you know, her history of, you know, having affairs and doing all the shady stuff that she's done, and especially her making the comment, I can't wait for the day he's dead and I don't have to live with him anymore.
Did Amanda support your mom or support y'all?
So I remember for several weeks, it seemed like, Amanda kept saying, well, he just had a heart attack and fell in the fire. And I was like, Amanda, how could he have had a heart attack and fell in the fire when A, they found a bullet lodged in his rib bone? And she's like, well, they could be lying to us. I was like, okay, well, if he had a heart attack and fell in the fire, why was everything gone from the fire pit? It's like the RTV would have been there, or the tractor would have been there. There would have been something. There was no indication to, especially to me, that he would have had a heart attack and fell into the fire.
So Amanda was not convinced?
She was not convinced on him being shot.
Was she supportive of your mother?
Oh yes, I mean, like I said, she was always glued to her side from the time I showed up over to the house and even after, and she was always with her.
Now, afterwards, the property, the house, and the contents of the house and things like that, fair to say that your mother and you and things were having some problems, some arguments over the disagreements, if you would, over the property in the house and trying to sell it and whatnot?
Afterwards?
Yeah.
Yes. I mean, it was, she immediately after this was all about trying to get as much money as possible.
Was Amanda being a go-between between you and the defendant at times?
If I remember right, yeah, she was very much involved, and you know, all of us. I remember all of us getting, you know, hit up about getting, you know, having money handed over to her or something along those lines.
When you and your mom afterwards were trying to figure out what to do with the house, because I guess it went into the probate part, all the property basically was frozen. Is that right?
Yes, everything from. It seemed like the day of the 5th, they froze everything.
So the accounts and things like that?
Yes.
But on the 5th, was your mom going around asking who was on the bank accounts and stuff like that?
No, she was actually asking those questions before finding my dad. That was another, like I said, her behavior. She kept asking all of us, do you have access to the bank account?
At the scene while you're trying to find your dad?
Yes, man, this is like us trying to figure out where he could be.
Now, was it odd at times that your mom and you would have to talk and communicate after your father's remains were found? Y'all still had to deal with the house and try to deal with that aspect. Did y'all communicate somewhat on that?
Yeah, man, we were, you know, I guess you said we went into kind of a survival mode, you know, trying to figure out how to take care of everything, and because, you know, we had, you know, a lot of animals we still had to feed and you know, keep lights on and stuff like that.
This is, again, is the Cellbrite. What I want to look at is if you can turn to page 2, number 3. So you see how at the top, when you go, it's from and to, so the first category here with the number is from your mother to you. And does that say, how early can you be home to help me get barn cleaned up? People are coming at 6:30. Did you see that?
Yes.
And what is the date of that one? Timestamp there.
4/8/2019.
So y'all were still communicating after the fact of what to do with the house. Is that right?
Yes.
Page 4. Let's go to number 9. From your mom to you, and there's a text message about Godis having a baby. Do you see that?
Yes.
And that was in April of 2019?
Yes.
Did you still have to take care of the animals and things like that?
Oh, yes.
Was anybody else there helping you take care of the animals?
No.
Were you still staying in the barn at that time?
Yes, I was.
I'm going to go to page 9. On 28 there, do you see it's a message from your mom to you? That's April 19, 2019. It says, people come to look at house. Said barn apartment was filthy, pooping floor, smelled so bad. Other realtor took pictures. This is beyond, I think she was trying to say unacceptable. You see that?
Yes.
And then the 29th message we have here on April 19, 2019 at 1:47, you replied to it, and what did you say?
Oh, yes. That is bullshit. What's unacceptable is our father being murdered.
Did you find that your mom was saying things to you that you believe were not true, or saying to other people things that were not true?
Oh, absolutely.
About how you were handling the house?
Yes.
What you were doing?
Yes.
How bad did it get? Did law enforcement ever get called on you?
There was a lot of times that I was never told, but animal control kept being called. And what I picked up off from the deputy who came out from animal control, he kind of acted like it was possibly a neighbor trying to get the animals. So that was the most occurrence of somebody from the Cherokee County coming out.
Did animal control ever come and take the animals away from you, or write you up, or lock you up, or anything like that?
No, sir. Every time they came out, they said, I showed them, their feed and, their hay. I walked them around. They looked at all the animals, and they're like, yeah, there is nothing wrong. All your animals look healthy. And
Do you know whether or not it was your mother behind that?
No, I do not know if it was her.
Was it during this time that we see here there was disputes going on?
Yes.
Now, this is page 12. It's number 40 on this extraction. It's from you. Now, you've got mother too. I guess she had different numbers. Is that what you put it in?
Yeah, by that time, she had to get a new cell phone because Cherokee County had her other cell phone still.
Did your mother, the defendants, start asking about money and paying things and stuff on the cars and whatnot? If you would, read this message for us that on April the 3rd, 2019, from you to your mother. What does it say?
I have been giving Amanda $200 every month for insurance. I have it documented. She sent me a text last week saying she canceled the insurance on the Toyota. The lies need to stop because we are not falling for them. Just how we know you're now going around Tennessee telling everyone that Chris and I will get into fights with Daddy. You want to talk about a disappointment. How about you filing a false police report against me? We are not stupid and we are not falling for your lies.
Got pretty bad between y'all?
Yeah, so the whole police report thing, I believe it was after I came back from my grandmother's funeral. I was contacted about meeting with a detective in Woodstock Police Department. Later to come out, the reason why I had to go to Woodstock is because since Cherokee County was handling the investigation with my dad, they could not get involved with this one. Well, I found out the police officer I talked to, he said that Melody filed a report that I threatened to kill her just like how I did my daddy. And
this is all after the fact, right?
Yes.
So is it fair to describe that as soon as you were after finding your father, the family was together for a little bit, and we've heard about the attorney, I'm not going to go into too much of that, but y'all then went and things separated. You, Chris, and Emily went this way, and Amanda went with your mom. Amanda and Chad Bruce went with your mom went that way.
Yes, that's correct.
Fair to say that y'all were close together, not pointing fingers or anything like that, but then as time went on, it just branched out.
Yes.
Father and father, the gap got wider and wider.
Yes.
But there were still, like on page 18 of this report, number 64 and 65, kind of an odd setting because you still had the house, and there's a message from you to her, 5:07 on May 21st, 2019. Did you leave the door unlocked? Do you see that message? Number 64 there.
Yes. Did you leave the door unlocked?
She replies and responds by saying the key is under the front row. You see that?
Yes.
So at times it could be, I guess, amicable, but would you describe it as just odd and weird afterwards? Just how y'all had to interact at times?
Yeah, I had to be very careful because I knew with her aggression towards us, because there were several times that, you know, if something happened that she didn't like, she would come up and start yelling at me and threatening me and stuff like that. I believe I talked to Detective Hayes, and he was the one that informed me that, you know, the memo recording on my phone, I'm able to do recording. So if I had, you know, any kind of interactions with her, I can record it, and at least there would be some kind of audio documentation of it.
Now, tell the jury again, who was Chad Bruce?
Chad Bruce, prior to this, was dating my sister Amanda.
Are they now married?
Yes, they're now married.
Is he close to your mom?
Oh, yes, very much so.
Did y'all have a time after this that y'all had an incident in the roadway outside the property?
Yes. So, you know, after all this happened, I knew I had to go find some work. I did mainly kind of like under the table type work. I didn't go get a full-blown job. I was trying to bring in as much cash as possible.
Working at a nursery or something?
That was, you know, I didn't immediately start working at my friend's nursery. I actually went and worked for somebody who I knew who had a landscaping, cutting, you know, lawns and stuff like that.
But at some point you and Chad had an incident in the...
Yeah, so I came home from working all day, and I pull up and I see Amanda and Chad at the driveway. By this time we were locking the gate, and they were standing there, and when I pulled up, Chad started threatening me and cussing at me, so was Amanda. I don't remember exactly what it was about, but I was being yelled at and cussed at.
Is Chad, was he aggressive with you?
He was definitely yelling and all. I stayed in my vehicle, but he never came like charging at me.
Sure, no fisticuffs or anything.
Yeah, nothing like that. He was yelling and cussing and calling me a piece of shit and all of this stuff. And I was trying, when this was happening, I was trying to hit the record button on my phone, and I somehow, you know, I'm keeping my eye on him and trying to hit the record button on my phone in my lap, and I somehow wound up calling my buddy Justin. And all I hear is hang up, call 911.
Good afternoon, ma'am. If you stand in front of Madam Clerk and be sworn.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Watch your step, stepping up. Step. And you swear.
Thanks, ma'am. If you need to adjust the microphone, you can. Please answer questions the attorneys may have.
Good afternoon. Would you please tell us your name?
I'm sorry.
Could you please tell us your name?
LaWanda Sample Rusk.
Thank you, Ms. Sample Rusk. We have a court reporter taking everything down today. Would you mind spelling your last name for us?
SAMPLE-8RUSK.
Thank you. I want to remind you that during your testimony today, we're not saying the names of any children, only using initials if we need to refer to them, including your own grandchildren or children. We'll only use initials or refer to them as your grandchildren, if anything, okay? Let me ask you, Ms. Sample Rusk, on January 6th of 2023, did you go to Rich Neck Elementary?
Yes, I did.
And what was the reason that you went there?
I went to Rich Neck to pick up one of my grandsons,
Okay.
who was a first grader there.
And you have how many grandsons that attended Rich Neck at the time?
2.
Okay. And when you got to Rich Neck, did you go into the office area?
Yes, I did.
And if you remember, who was in there when you first arrived?
When I entered the office, it was the 2 receptionist secretaries. And there was a student sitting to the right when I got in the office.
Okay. Do you know the names of either of the secretaries?
I believe one was a substitute there because the other was on vacation. I'm not sure, but the other one was there all the time, and she goes by Miss O.
Miss O.
No, yes,
Okay.
I think it's O. I don't know, but I think it's O.
That's okay. Thank you.
But we always call her Miss O because that's what my boys call her.
Okay. Now, while you were there in the office, did something happen that took you by surprise?
Yes.
Can you just tell us what it was, what you saw happen?
I was in the office for a little lengthy time because I was speaking with the receptionist. We were talking about cruises and different things. I'm sorry.
You can take a minute, take a deep breath, it's all right.
We were talking, and then a employee of the school, I don't know her name, I believe it's Miss Harris, I'm not sure. She ran into the office, and she said, she yelled something about a gun or shooting or something like that. So I was still on the side of the counter where I should be as a visitor in the school. The receptionists were still at their desk. But when the teacher ran in, she ran in and went straight to Dr. Parker's office and closed the door.
Okay, so the teacher went into Dr. Parker's office?
Yes, the entrance from the office.
Okay.
Because there's an entrance to Dr. Parker's office from the main office.
Understood.
So, and to both the principal and vice principal's offices from the main office.
So after that happens, what's the next thing you see happen right there where you are in the office?
As she ran in and shut the door, we didn't have any information. And then, or I didn't know. I can't recall exactly. I can't recall verbatim, but we found out it was a first grade class.
So you don't need to tell us what you heard, but really, or what you thought was going on, but just describe it visually. Like, what's the next thing that happens in the office where you are?
Miss O jumped up, got on the phone, and she called whatever code they call out to the teachers over the intercom to let them know that there was something going on.
Okay.
I was a little hysterical because when I found out it was a first grade class, I was ready to go down the hall to find out what was going on because that's my kids down there. So
Now, at some point, does another teacher come into the office?
after that, we called the police, everything. Then, just as I took I was wearing a crossbody purse. Just as I took that off and set that and my keys on the counter, I was going to go down the hall. Before I could get out the door, Miss Werner comes into the office and she's holding herself like this. And I see blood on her hand. And so, by that time, when Ms. Warner came into the office, I had gone behind the main desk that we're supposed to be on. I was back there where the employees would have been.
Mm-hmm.
I had stood behind there because I didn't know what was going on. And I took the little boy that was in the office, took him back. I said, look, you need to hide. I said, hide. I said, my name is Miss LaWanda. I got you. I said, you hide. The kid hit so good I couldn't even find him after I really milked and looked for him. But he was back shoved up under the one of the big copier machines.
So let me ask you a question. So while you were telling him to hide, and where are you when you're telling him to hide?
I went to him. I walked from behind the counter, walked to him, took his hand, let him know. I said, my name is Mr. Wanda. I have a grandson here. I said, you're going to be okay, but I need you to hide until we find out what's going on.
And
so I made sure he was secure. And then when I didn't see him, but I knew he didn't walk out the office, I knew he was secure.
So at that time, after he got secure, where was Miss Werner, if you know?
So I secured him before Miss Werner came into the office.
Thank you.
He did not see any of that.
Thank you.
I
So
got him out of the way because I didn't know what was going on. He did not see any of that.
I understand. So let's pick it up from that moment where Miss Werner, he's hidden and Miss Werner comes into the office. What do you see?
Miss Werner comes into the office, and before she came into the office, we locked the office door after the teacher came in and went into Dr. Parker's office. We locked the door. We didn't know what was going on because I locked the door, I ran and locked the door. Then so when I saw Miss Werner, she came to the door and I had to unlock the door for her. She came in and she was holding herself and she said, I've been shot. She was very pale. And then as you walk into the front office, to the right, immediately, like side by side with the counter, there was a principal's door. Ms. Werner fell there. Okay. When she fell, I lost it. But I was trying to keep my composure because she fell out. When she went down the wall, there was blood on the wall. So I went to her while the secretaries were doing what they were supposed to do, whatever protocol is. I don't know. I'm not an employee. I cannot speak on that. They were doing whatever they were supposed to do to make everybody aware, get law enforcement there, whatever.
Your Honor, I'm going to object to this testimony, this line of questioning. We are here again regarding Dr. Parker's actions and inactions on that day. This is beyond the time when Mrs. Werner had already been shot by JT. I don't see the relevance here.
Dr. Parker's inaction caused exactly this that's being described. So this is exactly the same as the prior ruling regarding Ms. Kovac's situation in the classroom. This is the shooting's aftermath, and it is the result of Dr. Parker's willful inaction.
Again, how is that relevant? She's charged with child endangerment, and we're talking about the medical response and the response to the people that see that in the office. Is there still child endangerment happening right now? Is that what you're alleging?
Absolutely. There is a result of the child endangerment. There is a prong of the statute that requires proof that the child was in danger and possibly deadly danger. And we have a grandmother who is shuttling a child to safety in that office as the event is unfolding. This event is entirely precipitated by the child neglect. But for it, none of this would happen.
going into narrative where she's just giving a narrative and not answering the question. Can you ask another question, please?
Yes, and if I may just sort of inform the witness, I'm going to need to ask you questions, so just pause with me for a moment and we'll walk through it step by step, okay?
Okay.
At the moment that you have described where Miss Werner fell down to the floor, can you tell me, at that moment, you've said you were with her, do you know where the office receptionists were?
Yes, she was on the phone. Ms.
Okay.
O was on the phone.
All right. And do you know where Dr. Parker is?
I didn't see Dr. Parker.
Okay. And do you know where the principal, Miss Foster, is?
I didn't see Ms. Foster.
Okay. And so while you're there with Miss Werner, and at the time that you let Miss Werner into the office, did you see Dr. Parker or Principal Foster?
No.
Okay. And so after you have seen Miss Werner slide down to the floor, what's the next person that comes to the office? Who is the next person that comes to the office is not a leading question.
I think technically it is because it presumes that somebody else does come.
Well-
So can you rephrase it to who was the next person that comes to the office, if any?
Did anyone come to the office after that?
I don't remember.
Okay.
I honestly cannot remember.
Did you ever see a police officer?
Okay, now, I can speak on who came, but as far as the next person,
Okay.
I want to be very specific
That's
with my
fine.
answers to make sure I'm answering this correctly.
Absolutely. Let me ask you a specific question. Did police officers come and attend to Miss Werner?
Yes, there was one officer I remember, I believe he was a sheriff's deputy.
You don't have to tell us any more about it. That's good enough. And at some point, do you find the child who had gone into hiding?
Yes,
Okay. And at some point later that day, are you reunited with your grandchildren?
yes, I was.
All right, thank you. I don't have any further questions for you. Please answer any questions from defense counsel.
Okay.
One moment, please.
Good afternoon, Ms. Sample Rusk.
Hi, good afternoon.
All right. You mentioned that when you were in the office, you heard a teacher, or you saw a teacher go into Dr. Parker's office and close the door, correct? And so you don't have any personal knowledge of anything Dr. Parker said or did at that, before that point, or after that point, right?
Well, I did see Dr. Parker after the police and everyone got there.
Understood, yes.
Saw her come through the office, but, and the principal as well, but in reference to Dr. Parker, no, I didn't see anything. I didn't see her at all until the end.
Okay. So you don't know what was going on in the office, right?
I don't know. All I know is she closed that door and stood there and watched us.
Hold on.
The
You said
teacher.
the teacher closed the door.
Closed the door. I did not see Dr. Parker at all.
Okay. So you don't know what Dr. Parker was doing in her office. You don't know what calls she was making or anything like that, correct?
Correct. That is correct.
Okay. You don't know what instructions she was giving, anything like that, right?
No, I don't.
Okay. Ms. Sample Rusk, is it true that you filed a lawsuit in this courthouse arising from these events on January 6, 2023?
Objection, relevance.
Oh, it definitely.
Okay, oh yeah, you can
Okay. It's definitely relevant, and it goes toward potential bias, Your Honor.
Okay, how's it not relevant?
Well, whether she filed a lawsuit in the suit or not, I don't understand how that's relevant to whether Dr. Parker committed child neglect. I don't see the connection.
I think the law allows parties to cross-examine on a witness's interest in the case. If she's filed a lawsuit, she may or may not have an interest in the case. That's proper grounds for cross-examination. So you may proceed. Do you need him to repeat the question?
Yes.
Please repeat the question.
Okay. Ms. Sample-Russ, you filed a lawsuit in this courthouse regarding the events of that day, correct?
A lawsuit has not been filed yet.
Okay. Have you made any demands of Ms. Dr. Parker or her attorneys?
I'm not sure I understand that. Have I made any demands of her? I'm not sure. Can you? I don't understand. I want to make sure I answer
Understand.
correctly.
Right. Regarding a potential settlement, or have you made any demands whatsoever of Dr. Parker or her attorneys related to that event, to that day?
I have not known. And as far as I know, there has not been a lawsuit that has been filed yet.
Yet. Okay. Do you know whether one has been drafted?
No, I do not know that.
Have you retained an attorney?
Yes, I have.
Okay. And is it your understanding that a lawsuit, whether it's been filed or not, would be against Dr. Parker as a defendant?
That is correct.
Okay. And before you came into that office that afternoon, you have no idea of anything that occurred before that point, correct?
That's correct.
No further questions.
Can you agree with the right?
No, Your Honor.
Thank you. All right, and the status for this witness?
Do you want her subject to recall? I would ask that we release her.
Okay, any objection?
No objection.
Oh, so and that means you are released, you are excused being a witness, so you may stay in the courtroom if you wish, or you may leave. Thank you very much. And watch your step as you step down.
The Commonwealth will next call Kelly Wells. Kelly Wells.
In front of Madam Clerk to be sworn.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Okay, please step into the witness stand. There's a step. So watch your step, and you can adjust the chair and microphone. Okay, please proceed.
Good afternoon. Would you please tell us your name and how you're employed?
Good afternoon. My name is Kelly Wells, Kellywells, and I am a forensic specialist with the Forensic Services Unit of the Newport News Police Department.
And as a forensic services technician with Newport News Police Department, what is your regular job? What do you do?
I respond to major crime scenes, to include homicides, aggravated assaults, any death investigation that is unnatural or unexplained, and just anything else that is deemed needing forensics.
And when you get onto a scene, what do you typically do with physical evidence that you find?
Typically, I initially take photographs, and then I identify the evidence that I see, and as well as search for additional evidence. And I collect that evidence and will either usually process it for fingerprints or swab it for DNA, and potentially send it to the lab at a later time. But it then is secured in our Forensic Services Unit.
How long have you been doing forensics work?
This is my 21st year.
I want to direct your attention to January 6th of 2023. On that day, were you called on to go to Rich Neck Elementary School?
Yes, I was.
Is that here in Newport News?
Yes, it is.
When you arrived at the school, were you directed to a particular classroom?
I was met by my sergeant at the time, which was Sergeant Ramdahall, and he accompanied me to classroom 11.
All right. And in that classroom, did you look for any evidence?
I did.
In that classroom, did you see a firearm?
I did.
Could you just describe where it was and how it was positioned?
Sure. When I entered the classroom, it's rectangular shaped. To the right is the front of the classroom, so the desks were facing towards that direction. And then to the left, there was a table that was behind in the back corner, behind the students' desks. On the floor by that table, there was a Taurus 9mm firearm on the floor. And then just in front of that, there was a student's desk that had a black and white backpack on the floor. And there was a Win 9mm cartridge case on the floor as well.
Okay. So let's talk about what a cartridge case is, just in case some people may not be familiar with that term.
Sure.
What is a cartridge case?
Lots of times people just generically will refer to ammunition as bullets. But typically, bullets, what you're thinking of is a cartridge. And the cartridge, which is ammunition, is comprised of a cartridge case, powder primer, and then a bullet, which is the projectile, all in one creates the cartridge. When the cartridge is loaded into a firearm and the trigger is pulled, the firing pin of the firearm strikes the head stamp of the cartridge, causing an explosion with the primer, causing the bullet to propel down the barrel of the firearm and out. And then the cartridge case that remains is then ejected from the firearm. It usually ejects back into the right.
So you have indicated you found one cartridge case. Where was that?
That was at the desk just in front of the table that was on the back left side. It was on the floor.
All right. And then with respect to the firearm, what did you observe about the firearm itself?
The firearm itself, I noticed initially that the slide was back partially. And the slide is the top piece of the firearm. And then I was able to get on the floor and look, and I could see at the opening that there was a cartridge jammed in the top of the firearm.
Okay. And would that have been an unspent cartridge, could you tell?
Correct. It had not been fired.
Okay. And did you determine whether there were any other unfired rounds or cartridges in the firearm?
Yes, once the firearm was cleared for safety by my sergeant in my presence, I observed 6 Win 9mm Luger cartridges and the 7th from the chamber.
All right. Thank you. Ms. Wells, please answer any questions from the defense counsel.
Sure. Yes, sir.
No, we don't have any questions.
Okay, no questions. All right, and the status for this witness?
She'll remain on call, Your Honor.
Any objection? Okay, so Ms. Wells, you're free to leave the building, but you're still sequestered, so you cannot discuss your testimony until you've received information that the case is over.
All right.
Okay, and they have your contact information, they can call you back.
Yes, Your Honor.
Thank you.
Thank you.
All right, next witness?
Commonwealth calls Jennifer West.
All right, thank you. Please stand in front of Madam Clerk to be sworn in. I get to walk all the way around the front.
Raise your right hand. Do you swear affirm the testimony you're about to give is the truth, full truth, and nothing but the truth? I do.
And Ms. West, please enter the witness stand right here. And as you go around the corner, there's a step. Watch the step. You can adjust the chair and microphone. Please answer questions the attorneys may have.
Good afternoon.
Hi.
Could you please tell us your name?
Jennifer West.
And Ms. West, how are you employed?
I'm a teacher.
Now, I want to take you back to January of 2023. Were you a teacher then as well?
Yes.
What school did you teach at?
Rich Neck Elementary.
How long have you been a teacher?
23 years.
And what grade did you teach at Rich Neck back in January 2023?
First grade.
Could you help us understand where, if you know, do you know where Miss Werner's classroom was?
Across the hall from mine.
Okay. Taking you back to that January 6th date in 2023, on that day, based on, for whatever reason, did you end up observing a student named JT while he was at recess?
Yes.
And where was your class at that time?
Also at recess.
Okay. And while you were observing JT, could you describe, just as if it was a movie that we were watching, just the actions that you observed?
He and another
And I'm sorry for interrupting you, but I need to at this point because I forgot to remind you, we're not using any names of students. You can say a student or you can use initials, but please don't say the names of any students.
He and another student kept going behind the rock wall, and there's a large tree on the playground. They'd go back there and come back out, and I just was watching their interactions.
Do you know the initials of the other student?
RR.
And do you know the initials of the
JT.
first? Okay. So describe for us what exactly JT and RR were doing in as much detail as you can remember.
It's hard to remember specific details, but I did write down notes the day of, and I reviewed those before coming.
When you reviewed your notes, did that help you refresh your recollection about what happened?
Yes.
Okay, well, then what happened?
They were staying together, very close together. They kept going behind the rock wall, going behind the tree, kind of being secretive, trying to avoid other people.
Okay.
I'm going to object.
I'll agree that the trying to avoid other people part should be stricken.
Okay. So sustained, strike that part, trying to avoid other people. But you can consider going behind the rock wall. Next question.
Ms. West, when recess ended, did you have a conversation with RR?
After we got back in the building.
Okay. And before I ask you to tell us what RR said, can you just describe his physical demeanor, how he appeared to you?
So I asked him to come speak with me to ask him about what we had observed at recess.
And before you tell us what he said, I just want to know his demeanor, how he appeared.
He was visibly shaken, nervous. I asked him what they had been doing, and he said...
Okay, hold on. Before you tell us what he said, I'll ask judge and counsel if we need to voir dire this witness. Just hold on just a moment, okay?
Your Honor, I think based on previous rulings that the court will allow her to testify, but we're objecting for the record that any statements that she may have heard from RR are hearsay.
Okay, you're continuing. Your exception is noted. Thank you. All right, you may proceed, Mr. Jenkins.
Tell us what RR reported to you.
He first said he couldn't tell me, and I reassured him that he could. And he said, I can't. He said that he would hurt us, that he would blow us up. He was referring to JT at the time. And then he said that JT had a gun. And at that time, I asked him what it looked like to kind of confirm whether it was real or not. And he said that he saw the bullets, and I said, well, what color? And he said they were bullet colored. And at that point, he was crying. And I had RR come into my classroom.
And then once RR was in your classroom, did you place a call?
I did. I called the front office
And what was the purpose of that call?
to report what RR had told me.
Okay. And who answered the phone?
Mr. Sims, our music teacher.
Okay. Thank you. If you could give me just a moment. I want to now fast forward a little bit and jump forward. Later in the day, did some students come running into your classroom?
Yes, I think it was just before 2 o'clock.
Hold on. Can you back up from that for a moment and just walk us through what happened that you observed or heard in the moments before students came into your classroom?
I heard a gunshot, and I immediately knew what it was. And I went to my classroom door, opened it, and Abby's students came running out, and I ushered them into my classroom. And I could see that Abby was standing. She had just exited her room, and I could tell that her hand was bloody, and there was blood on the floor. Once the last student that was on their way out came out, I shut my door and proceeded to lock down, turn off the lights, and settle the students.
In as much detail as you remember, can you describe the behaviors that you observed, the demeanor that you observed of the students as they came in?
They were terrified, many of them crying. RR was situated behind me. I was sitting on the floor with the students around me, and he kept repeating, I told you. I tried to keep you safe. I told you. And I just kept reassuring. There were a few students who were trying to tell me what happened, but I didn't want my class that didn't witness it to hear all of the details. And I just kept reassuring them that we were okay.
Were some of the children were crying?
Yes.
All right. Ms. West, thank you for your testimony. I don't have any more questions for you right now. Please answer any questions from defense counsel.
Yes, sir.
All right. Good afternoon. How are you?
I'm okay.
I understand that you're upset, and that's reasonable. Whose student was RR? Was that your student?
No, that was Abby's student.
Okay. Did you have a relationship with RR? Or?
I try to have relationships with as many students as I can. So, yes.
Okay. And when you had contact with RR after recess, could you tell us again what prompted that?
What I was observing at recess was RR and JT kept going behind the rock wall, behind the tree, and I asked him to come tell me what was going on at recess.
Okay. Did you, during that recess time, did you believe that JT possessed a firearm?
I was not convinced until I spoke with RR.
Okay. So while the children were out on the recess, you did not feel a sense of danger or imminent harm to the children. Is that correct?
I don't really know how to answer that. We were kind of observing. I had been told that Dr. Parker had been made aware.
Your Honor, I'm going to object to that statement.
Objection to that. If this is a question that he asked, and moreover, just a moment ago, he asked the question, what prompted her to talk to RR? And she's entitled to answer the questions that he asks.
And so, again, we don't know what the answer is going to be, and it doesn't make it necessarily admissible. But that is hearsay that she was told. So at this point, you cannot consider that unless it comes in under another exception.
Thank you, Your Honor.
Next question.
Okay. So based on your observations of RR, you weren't convinced that he possessed a firearm. Is that correct?
I was convinced they were hiding something.
Okay. Had you believed that he possessed a firearm, would you have taken steps to exclude him from the presence of the other students?
I'm not sure how to answer that.
All right, I'll ask it a different way. If a student possesses a firearm, should you take steps to exclude them from the presence of other students?
That's the administrator or security's job.
So as a teacher, you don't feel like if a child possesses a gun, you should take steps to ensure the safety of those classmates?
If a child possesses a gun, I rely on the people whose job it is to check the child. And
I'm not talking about checking. I'm talking about protecting the other students.
I understand that. But it also could be protection of the other students by not exasperating the situation.
Okay, so you're saying if a student possesses a firearm, it's better to leave that student in the presence of other students so the students won't become exasperated? Is that what you're saying?
No, I'm saying I would contact security and administration, and they will handle the student.
Okay, so you're essentially saying it's not your responsibility to protect the students.
That's not what I'm saying.
What you're saying is you're going to rely on somebody else to protect the students. Is that correct?
Sure.
Okay. All right. Did you have any conversations with Dr. Parker prior to the shooting?
Yes.
Okay.
It was, I don't know that I would call it a conversation. It was an interaction that lasted about 5 seconds.
Okay. Did you tell her that you believed that JT possessed a firearm?
No, that was prior to my conversation with RR.
Okay. Did you possess any means to communicate with the office while you were out on the playground?
Based on my notes, there was a walkie-talkie. I personally don't remember having it in my possession at recess. I even can't remember what the protocol was that year because they've changed so much. Sometimes there's one walkie-talkie per grade level. At this time, every teacher has a walkie-talkie. But I do not recall the specifics of the walkie-talkie that day.
So you don't remember if you had one or if Mrs. Warner had one? Or...
I do not know.
Okay. Do you remember if anybody, you or her, tried to make an attempt to contact the office while out on the playground?
No, I did not.
Okay, that's fine. So you didn't observe Dr. Parker's behavior or interactions anytime?
Personally, no.
Can I have a moment, Your Honor? I'm sorry. So when I asked you the question about the walkie-talkie, I believe you indicated that when you looked at your notes, you saw that you indicated there was a walkie-talkie.
That I had one after recess. I do not remember the specifics of it before.
What do your notes say?
That I heard Mrs. Kovac on the walkie saying that she had the shooter.
Okay. I think so. That's all the questions I have, Your Honor.
Thank you, sir. Are you ready?
Yes, Your Honor.
At the time that you hear Ms. Kovac on the walkie-talkie, where are you?
In my classroom with mine and Abby's class.
Thank you. We know, as you testified, you were observing RR and JT at recess. Without telling me anything that anyone said to you, was your reason for observing them based on things you had heard from other faculty?
Yes.
Your Honor, okay, one moment.
Objection. He's back to work trying to get him to give city testimony. So, Deputy Chief. He's basically asking, did somebody tell you that there was a problem, which is hearsay, and he's asking for a response.
I'm not. I'm asking for her reaction to receiving information. This is exactly the same in 100 cases where we have asked a police officer, did you receive information that caused you to go to such and such address?
Okay, but there was leading in there because you were leading her to a particular answer. So can you rephrase? I'm going to sustain that objection based on leading.
So, did you go to recess?
Yes. I was later than normal.
Okay. Was there a reason that you were observing JT and RR?
Yes. 2 teachers told me that this is...
So, Judge, if I don't point the witness to something, that we're going to encounter this. So, we can't have it both ways.
Why can't you say without telling me the reason? Was there a reason?
Because the last time I tried to phrase the question that way, it was ruled leading. So I will rephrase the question. Ms. West, without telling me anything that anyone told you, what caused you to observe JT and RR at recess?
Okay, that was not the question that I stated would be the permissible question. So she's observing them, and I guess you're trying to she's observing them based upon a reason. And then what would be the next question? When she says, I'm observing them based
is
upon
the
something
reason?
somebody said to me, then what would be the next question?
That's the whole question. If she says, I'm observing him based on what someone said to me, I'm done. That's what I'm trying to get out of her. That's it.
Okay, so that's my question. The proper question is, without telling me what was said to you, what was the reason that why were you observing him?
I think that's what I just said, but the judge has asked the question.
Okay, but you have the question, Ms. West.
Now I'm confused.
Okay. Was there a reason you were observing JT?
Yes.
Okay. And without making this word somebody said, what was the reason?
There was concern that JT had something that he shouldn't have.
Thank you, Judge.
Any recross?
Sure. So based on your observation, you did not conclude that there was a danger to the students from JT. Is that correct?
No, not at recess.
Okay.
It was following recess.
All right. And that was your concerns came to fruition after your conversations with RR.
Yes.
Okay. So there was nothing to prevent you from excluding JT from his classmates. Is that correct?
Nothing to prevent me from?
Yeah. You could have, if you perceived that there was a danger, you could have
excluded him from his classmates. Is that correct?
But if I suspected what I had been told about, that could have made things worse.
Okay. Did you attempt to take RR to the office?
No, I called the office and reported what RR told me.
Did you attempt to take JT to the office?
I did not.
Okay.
My last interaction.
Okay. Did you yourself attempt to contact the police about your concerns?
No, I called the office.
Okay. That's all the questions I have.
Anything further for this witness?
No, Your Honor.
And status of Ms. West as the witness?
I'd ask that she remain subject to recall, constructively sequestered.
Same.
Okay. So Ms. West, you are still a witness. You are still sequestered. You may not discuss this case until this trial is over. But you do not have to remain in the building. You do not have to remain in the witness room. You are free to go about your daily life. And if you get a phone call that you need to come back to give further testimony, please come back. All right. Thank you, ma'am. You may step in. Thank you. All right. Next witness.
Your Honor, I'm going to ask that we take a break, and there is something that we need to discuss with the court.
All right, and it's been about an hour, which is a good wake up stretch break after lunch. So we'll ask the jurors kindly to retire to the jury room while we take up a motion.
on, hang up, call 911. And I was like, okay, so I did that and I called 911. And by the time 911 got on the phone with me, Amanda and Chad were in their vehicle and he pulled right up next to me and he was cussing and yelling at me. So you could definitely, if you have the 911 recording, you'll be able to hear him.
So the tension was spreading to other people too?
Yes, I mean, him, Chad and Amanda, pretty much within a month of after of this happening with my dad, they became fully against us and accusing us of stuff.
Scott, I don't really have much more. I have a couple more topics, and then I'm going to sit down and let the defense ask you some questions. I want to ask you about Rusty.
Okay.
At what point did you learn about Rusty?
It was sometime around not Amanda, but Emily's wedding. I know it was brought up that it was odd that Melody wanted to have him there at the wedding. I don't ever really remember meeting him as a child. I remember meeting his dad, and also, Martha Jane. Less than a handful of times we went and saw them through our childhood, so I don't remember Rusty.
Yeah, so Scott, what I want to know is, on July 5th of 2018, was Rusty Barton even in your mind when this was going on?
No, not at the moment, no.
Did you learn more stuff after the fact?
Oh yeah, man, more came out.
But your dad didn't know about Rusty Barton?
Yes.
How do you know he knew about it?
I knew at one point, my father sent me a text message saying along the lines of the girlfriend of Rusty Barton that your mother's having an affair with contacted me. I don't remember, what the rest was said in that text message, but I knew by that point he was aware of Rusty.
Your dad got a message about Rusty?
Yes, from what he texted me, he got a message from a woman that he was dating, apparently.
So the girlfriend of Rusty?
Yes.
This is S-Fair 6. I tendered yesterday. It's in evidence, and I want to go to... Do you remember talking or texting with your dad exactly what the language was about Rusty?
I would have to see this kind of recap my mind.
Look at S6, and for the record, I re-tendered it back into evidence, but this is number 23. It's your dad's sale from him to
Ron,
you.
I prefer to go ahead.
It's October 20th, 2017 at 9:19 a.m. Do you see that?
Yes, sir.
So deal with it tomorrow? Yes, ma'am. Okay, so we'll
send you a
start at
text.
8:30.
Read that into the record.
Not 8 a.m. With that being said, how much time do you think that's going to take? And let's try to do any other motions and objections so we can get rolling. So do I ask the jury to come at 9 or 9:30?
I'm going to 8:30,
Oh, yes,
so
sir.
we could get going on dealing with the admissibility of it right at 8:30.
Okay.
You want to say 9:30? Just.
I'm pushing.
Okay, well, 9:15. Okay. Well,
Okay, so we'll resume the judicial proceedings at 8:30 to take up the anticipated objection. I will ask the jurors to report at 9. Usually it still takes about 5 to 10 extra minutes to go from that to actually in the box and ready to go. All right. Anything else we need to address today?
No, Your Honor, thank you.
Okay. And then Sheriff will let the jurors know that they are adjourned for today. I'll go back and, let me bring them out to give them the reminder of sequestration, just on the record. Okay, thank you, Sheriff. Bring the jurors out, and everybody please stand as the jurors come out. jurors, so you all can stand in place or you can have a seat, but this will be quick. Up to you if you want to sit or stand. But we'll wait till all 14 are in the box. And you can sit or stand, this will be quick. You all may sit or stand, this will be quick, up to you.
14 jurors in the box.
Thank you. Now I have to do my triple check, it's like you know. Based upon witness scheduling, we don't have any other witnesses available to provide testimony for today. So we are going to adjourn and take our evening recess. It's about 3:22 p.m. So we would like you all to report tomorrow to the jury room about, let's say, 9 a.m. and then we'll get going and go promptly from there. Any issues, any questions that we need to address before we take our evening recess? Okay, yes ma'am.
I have a question, but I don't think this.
Okay.
I don't know if we should ask now or what.
Okay, so I'll give you a chance to ask the bailiff the question, and then he'll bring it to me. Or ask my
It was about the some of the everything that went on, some of the questions.
Okay, you want to ask a question? Okay, so write it down and bring it in the morning, and we'll address that question in the morning because jurors can ask questions. It's not typical or normal procedure, but it's not prohibited by law. So I'll address your question in the morning. And please remember your sequestration. Do not discuss this case. Do not allow people to approach you to discuss it. Do not research it. And I'll see you in the morning. Yes, sir.
In the event that there is an objection and we are not clear on what part is to be omitted, may we ask for that clarification?
So, and everything I respond to in terms of discussing jurors, I have to consult the attorneys to their responses, proper procedure. So I will answer that for you in the morning to the best of my ability. So this is the rule of law and we follow the rules and I'm constrained by those rules. But to reiterate what's been stricken and what you can't consider, let me get their input and I will answer it in the morning. All right, anything else? All right, so Sheriff will escort you out. Thank you very much. Thank you. Okay, and the attorneys can research those and give me your positions in the morning as well.
Legal measure chairs.
Yeah, leave your homes. You cannot take them home. And then, they'll be secure here. I know we have at 3 p.m. we get a shift change at bailiffs. But yeah, leave them there. Thank you. Leave your notebooks in the morning. Thank you. Anything else before we recess? Okay, nothing for comment. Anything else before we recess?
No, Your Honor. I will let the court know that I do have some concerns at this moment. We can talk about it tomorrow. For them, it seems like the jury members are aware that some of them, or one of them, or some of them have questions. It sounds like there may have been some discussions that I'm very concerned about.
Okay, we'll address it in the morning. And again, one wanted to ask a question, but we don't know what her question was. And we'll get your positions on how we want to treat that. And then the other gentleman wanted to know if he can have clarification on the objections when it's overruled and stricken or sustained and what he can consider and cannot consider. So give your positions in the morning. You'll have time to research it and we'll address it in the morning.
Thank you.
All right. Anything else before we recess?
No, Your Honor. No, Your Honor.
Okay, we're taking our evening recess. See you all in the morning. Thank you very much. Thank you, Sheriff.
All right, so the Kurt has not the Kurt, but the court has adjourned for the day. That is what has happened. And playing that, I'll be right back. Got to do a couple of chores, but I'll have the TV on, at least the phone by. Okay, understood. So, see, at this point, the shot the bubbles moving around in the background. So, I'm thinking of doing is we're going to be probably playing the other trial. We'll be doing that. Now, I was thinking about like yeah, I am doing a new stream. That's what I'm doing. And we will be doing this trial. Yeah. So thank you. We will be starting a new stream about the Melody Ferris trial. That's what we're going to be doing. So this one will end, and then we'll do the other one. Okay. So keep an eye out for another stream that's about to come up. That'll have to do with the. Okay, Bubbles. Thank you. We'll have to do with the Melody Ferris trial replay. Okay. So thank you all for coming, and we're going to be just starting a new one right now. Okay. And go.